that matter when
What matter?
tender matter will not with regard to that bid capacity calculation of existing commitments.
Oh, calculative.
Yeah.
What is this? Oh, yesterday they gave.
Before I show the calculation, if I make a separate date,
Before you show the calculation, that's the only thing you have to show us.
5 sheet before the calculation, only one thing, page 56, where the where bid capacity is dealt with. I'll just read 2 lines, Miller. What is it mentioned is that applicants who meet the minimum qualification criteria will be qualified only if their available bid capacity at the expected time of bidding, which is very important, my lord, is more than the total estimated cost of the works. My learned senior last time shows 3 pages, my lords. 169.
I am asking this, what is the calculation? Have you ever gone through it?
No.
Give a copy.
One copy.
Give a copy.
Yes, my lords.
If you don't have a copy, give it to me. My copy, give. We'll share. Brother, what's there now? N minus B.
Yes.
So A is the maximum annual turnover for the year.
Yes,
So this is what is the annual turnover.
yes, ma'am.
Existing commitment is this.
Yes, ma'am.
That is B. Then bid capacity.
I don't think the budget went also, but that's the issue. No, I'm going to it is a total bid capacity. This being commitment from will be market comes balance growth capacities like this industry for example. But that is what happened. But I have gone through it. In fact, I have understood what Madam Das is trying to take your notion.
I have not understood.
No, I'll tell you.
If I may,
I'll clarify. What you want to tell me, I'll tell you. C is doing this calculation based on page 56, clause 7. C is relying on the word, dynamism. That's what let me clarify. C is relying on the word in clause 7, page 56.
Yes.
Applicants who meet the minimum qualifying criteria will be qualified only if their available bid capacity at the expected time of bidding is more than the total estimated. But the word is at the expected time of bidding. But at the expected time of bidding, they have taken the date when the tenders are dropped.
Sorry.
Plus,
that has to be.
That has to be. That is how they are interpreting. And other than that date, whatever amount he has disclosed
that is a reasonable. That's a reasonable interpretation.
I'll go little further. Little further. It's subject to whatever you are saying. I'll go little further. But there are 2 things here. At the expected time of bidding, in this very same bid, very same tender notice, on this very bid capacity, you are disqualifying him, calculating those 2 additional works. That is kindly similar, page 171. You cannot have double standard, 2 standards for the same tender. That is what you yesterday asked the question.
Yes.
Can you see page 174. You cannot have two different types of calculation. Kindly see page 174. The same bidder became L1 in three works out of the same tender notice.
174.
Right?
Yes.
Kindly see. This is estimated value of
What is the estimated time of the bidding in this 174? It is the same.
3.22 crores.
Same.
Right. Now here is little more. It is 3.92.
Yes.
No. Kindly see, here you are disqualifying taking those two additional works into consideration.
No, what it says.
Kindly see. The first lowest bidder, Krishna Mahapatra, have been disqualified in combined evaluation due to insufficient bid capacity. The combined evaluation, where from it comes. Because he is L1 in three works.
Well, it's page
This
55.
combined evaluation plus page 55. Kindly see. They cannot have two different standards for the same work, same tender.
Yes.
Kindly see page 55.
Yes.
Plus 6.
Yes.
In case if any bidder stands first lowest in multiple bids, combined evaluation will be done to decide the number of works to be awarded. The authority reserves right to accept one or more number of works depending on technical qualification without giving the choice of the bidder for better interest of the law.
Yes. Yesterday there was one matter.
There was. But now what have you done? You have followed this because he is L1 in three works. Now you are disqualifying him on the same standard of taking two additional works into consideration as regard his bid capacity. Now, so far as this bid is concerned, you are minus.
No, there are two aspects.
Right.
Because if this clause 6 is to be interpreted, suppose if he has been, he has qualified himself, he is qualified himself in all the three cases.
That has to be understood.
That means so far as the bid capacity is concerned, that was found to be correct, to
Correct.
or meet the requirement.
Has to qualify.
Only thing is that he cannot be awarded the simultaneously all the three contracts. He can be awarded one or more depending upon his bid capacity.
Right.
Correct. If the bid capacity needs two consecutive work, then in that event he can be awarded two works. But if the bid capacity needs only one work, then he will be awarded only one work. Because the word which is used is one or more number of works depending upon a technical qualification.
Any number.
So it may be one or more. One is static.
Yes.
One is a static.
Yes. One is this type.
More is variable.
Variable. Definitely
So-
variable. Depending on his bid capacity.
Correct.
Absolutely.
Suppose the bid capacity is 300 crores.
Yes.
And then after applying this formula, it appears that he has a bid capacity of 700 crores. And if he's qualified in three, then at least can be awarded two.
Two.
Because he has both the capacities.
Mathematical calculation.
That's precisely the one. So this disqualification is on that basis, or it is on a disqualification is on the basis of
Bid
a
capacity. I mean, those
bid capacity in relation to
That is
six,
very justified. Yes. Yes.
6 or in relation to 7.
Yes.
I am asking whether
Yes.
it is disqualification
Yes.
is 6 or a 7.
I'm so glad. But that's the only point they are required to clarify. But this Annexure 9 series, if you are taking into consideration
6 series. You are taking us to page 174.
74,
Yes, 9 series.
you
Yes.
find two works he has been disqualified out of the same tender notice. So if you are, while calculating the bid capacity in respect of these works, you have considered these two works, which now you are saying that no, it will not be applicable here. How can you have two double standards for the same tender?
No. Actually, when a bid capacity is considered on an independent basis,
Absolutely correct.
or for each of the work, it is considered on an independent basis. That has to be, sir, suppose if the bid capacity is 300 crores, then for each of the work in which he has been adjudged as L1, he will be evaluated on the basis of 300 crores first. The moment it is found that he is L1 in respect of 3, then clause 6 will come into play, where the discretion is left to the authority to choose either to award 1 or to award more than one. So bid capacity initially has to be adjusted under clause 7.
Right.
And that is what he wanted to say, that under clause 7 he is qualified. Then we have disqualified him in respect of 2 works, but qualified him in respect of 1 work.
No, my little submission, my humble submission.
If I understood
But my humble submission would be, if a Lordship considers clause 7, bid capacity as on the date of bidding, he has to qualify in respect of each of the works he participated.
True.
Right, madam?
True.
Now,
Independently,
Right.
separately.
separately, definitely. But the cutoff date, as per clause 7,
Is the last date of submission.
but that they have not defined, but
No, but that should be
They have not defined it.
time of bidding means
expected time of bidding.
expected time of bidding is that when they have notified the time of bidding, the submission of the
That nowhere such a definition is coming, but the
we will give it.
Lordship, either the date of notification or the date of dropping the tender or the date of evaluation of technical bid or financial bid. That your Lordship will interpret in the manner that there I have no much very. But only thing is, Lord, if your Lordship sees this page 174 and 75, there cannot be variable bidding capacity. There cannot be.
That's true.
There cannot be variable bidding capacity.
Correct.
Now,
That's true.
bidding capacity will be 1.
Yes.
Now, at the time of adjusting his bidding capacity, you are taking work number 1, 2, 3, 4 commitments, 4 commitments, and disqualifying him for 2. Now, on the same analogy, these 4 are also to be taken into consideration for this one. My point is this: you cannot have a 2 type of assessment.
No. That's true.
Yes, if that is there,
It should be that for 3 works,
Yes.
independently they have to arrive at the
Exactly.
bid capacity
Yes.
as per the formula given in
Yes,
clause 7.
yes.
Then say that his bid capacity, say in this case, this is there.
But it needs to be one amount.
Correct. This they say is 530.
Yes.
Correct.
So that 5.
Yeah, well, 530 is static for all the 3 works.
Exactly.
I understand.
Yes, that's what
a
I'm-
very common,
I'm saying.
I'd say common sense
Yes.
one can have.
Yes.
It cannot
It
be,
cannot increase or
it is
decrease.
not a variable in nature.
Exactly. That's
Now, 530, if bid capacity minimum is 321,
Yes.
then for
530.
2 works, 321 into 2,
Yes.
it should come to 642.
Yes.
It should come to 642.
Clearly matches.
And if it is 642
Two.
is there, then he is having a 530, so he
Yes.
will be awarded only 1 contract
Clearly.
based upon
Yes.
this 530.
Yes. So whether for these 2 works, 530 has been considered. In my humble opinion, it's not.
So his bid capacity was considered in what manner? Where it is that?
That is considered, kindly see page 174. Insufficient bid capacity.
No, is only 9% less than the corresponding has been
See,
put to the tender.
then estimated value is 3.92 here. Kindly see the interesting aspect. Estimated value, page 174, is 3.92. If he has 530, then where is the question of disqualifying him here? On the ground of insufficient bid capacity. The next also the same. Bid estimated value 3.45. If he has 530, then what is the question of disqualifying him on the question of insufficient bid capacity? Page 175.
No, insufficient bid capacity will be there because of clause 6.
So what is the question of, again, it's coming down than the estimated value. It is beyond the estimated value. His capacity is there. How do you disqualify him for these 2 works on the question of insufficient bid capacity? There I am asking, complaining a discrimination. Article 1. That's the point. Yes, bro. That's the straight point. There is no other case here. If that you cannot have 2 standards.
But Mr. Roth, only thing is for this work actually, if this capacity is found to be correct, then the disqualification in other capacity, that may be a mistake, that may be wrong.
It's a relevant.
That is he who has to come forward and then challenge it.
Principle. It's a question of who is coming for your lordship.
But we are concerned with this particular ascertainment.
One standard and other was there. Can there be another standard?
They cannot. That we will make an observation that this is not. But we are concerned with this word.
Why I am saying this, Lord? This expected date of bidding, they have interpreted it at the time of technical evaluation. That is what they have done.
How can they take it? I think it's a 2%.
Yes, that is how they have calculated the whole work. Now, for this particular work, they are adopting a different standard. That is the issue.
What they are adopting?
This expected time of bidding, they are interpreting the date of submission of bid. For assessment of other works, they are taking the date of evaluation of the tender. Because other than the date of evaluation of the tender,
He may have some other contract.
Yeah, that's the point. Page 171 and 172. He has already 7 crores of commitment with him, which you are not calculating here, whereas you are calculating there.
If I may clarify my lords here, my lords. If I may refer to the second last page, which is the combined evaluation of the first of this bidder, my lords. Because it's a composite tender wherein a lot of works were called for, my lords. He was, my lords, the second last page is a combined evaluation of the L1, Mr. Krishna Mahapatra. Second last page, my lords. Here the calculation is shown at the top, my lords.
In my opinion,
What is the calculation?
Here the calculation which is submitted, my lords. It is for all the works where he had participated, because the point, this box which shows here in 4 works he had participated, my lords. Correct, my lords. Then thereafter, if I may refer to the last page, my lords, what is the authority has done in this matter? Last page, the serial number 1, so and so. Because if he has been given work in one matter, my lords, automatically for other work his bid capacity will decrease. If he has been given work in one matter, for example, in this matter.
Wonderful. Yes.
That is how it has been. That
would be in anticipation that the work will be awarded to him.
Yes.
That was awarded in the combined evaluation. That is what I'm trying to show. He was L1 in 4 matters, my lords.
Sir, mere declaration as the lowest bidder does not create a right to a contract.
My lords.
Say, that is not permissible.
Yes, my lords.
Matter.
As per 55.
I do not think so. The manner in which you are heading is correct. If both 6 and 7 has to be interpreted, it gives a different color.
My lords. I may be given 5 minutes to explain, my lords.
10 minutes.
Yes, my lords. 6 talks about combined evaluation, my lords. 6, page number 55, clause 2.6. Page 55.
Yes.
In case any bidder stands first lowest in multiple bids, combined evaluation will correct, my lords. Here, my lords.
Please. First.
My lords, 5 minutes to explain, my lords. 5 minutes to explain.
No. We have to then please explain.
Yes.
I am just asking you to explain the first sentence. What does it mean? How you will adjust him as a first lowest bidder?
Yes, my lords. He will adjust as first lowest bidder.
What is the parameter?
Parameter is page number 56, bid capacity.
Bid capacity.
In all
Bid capacity in what sense you will?
Here, my lords, what calculation they have taken, my lords. If I may refer to the first page, the calculation of the bid, which is also there in the bid.
You clarify this. So, I was just thinking this line, in case if any bidder stands first lowest in multiple bids,
Yes, ma'am.
how you are adjusting as the first lowest bidder in multiple bids on the basis of 7.
Yes, my lords, as per this calculation,
Correct.
which is given, my lords.
7 talks about what?
It-
Whatever is already disclosed,
It's the
whatever is already disclosed, on that basis you will do it.
yes, my lord.
Will you take into consideration the anticipated that he is also L1 in, he is supposed to get it?
Anticipated, my lords. As on 7-2, when the technical bid was opened,
Correct.
7-1 with my learning senior was showing 170. 3 crore 48 work was already given to him. Hence 3 crore.
Given means, have you entered into the contract?
Yes, my lord.
Have you awarded the
Yes,
contract?
my lord. Yes.
You awarded the contract?
Page number 117.
Okay, so according to you, estimated time of bid means the technical evaluation.
This is what the authorities have done.
Okay,
And accordingly, this page number 170, 3 crore 48 lakhs was deducted. And 2 crore 10 was given in his document as admitted work in hand. Thereafter, 3 crore 48 was deducted, my lord. And thereafter, this figure of 530 had come. And that is more than the bid or more than the tender value of the present work. Also, my lords, because considering this, because this is a composite tender, my lords, he had given bids in multiple matters. In 4 matters, he was declared as L1, my lords, as per the combined evaluation sheet, which is signed by all the authorities, my lords.
yes.
Considering that, at the last paragraph, they give one matter, this particular matter, to the successful bidder, which is opposite party number 7, my lords. Last paragraph, my lords. And
So,
this calculation is also mentioned in the combined evaluation proceedings, my lords.
so if according to you, this bid capacity of
530.
who is this Krishna, whom he has been awarded?
He has been classified as L1.
Correct. So you have ascertained the bid capacity in Roman 4,
Yes, my lord.
last bid, as 940.
Yes, my lord.
If I understand.
Yes, my lord.
And here also, his bid capacity is considered as 940,
Yes, my lord.
correct?
Yes, my lord.
Then give me the second figure, work awarded in other tender notice, 409.
This is in the same tender, my lord, various works were given. In the same tender, these were other matters where what was the requirement and where he has been qualified, my lord.
So 409 was considered as an anticipated
No, my lord.
awarding of the
No,
contract.
my lord. No, my lord. This box is not anticipated, my lord. These works were considered in because it was a composite tender. In these works, he was declared as L1. And accordingly, as per clause 5,
So have you awarded this particular
No, my
contract of 409?
my lord, only
409?
my lord. Only second
Then
work
what is the meaning? I do not know. My English is very bad. Work awarded. What is the meaning of the expression? What English language talks about awarded in a past tense when it is used, how it is to be interpreted?
Well, here it does not.
If we say the work awarded means what? What language shows?
Here the word.
That the work has already been given to him?
Well, it's here the word is not here.
No, sir, first page.
First page is the
409 figure.
The matter we are getting it, he has not disclosed. I'm so sorry.
Well, if I may correct myself, my lord. Here I was wrong, my lord. Here 409 is serial number 1. Here 409 is serial number 1.
So it is not an awarded contract.
This is an awarded contract, my lord.
You have given a contract.
Well, it's recommended. Recommended.
No,
Whether it is awarded or not, my lord, that
I am again asking. Recommended means what? That he has been given more than one contract.
I'll just give me 5 minutes. I'll pass it. I'll just ask the authority whether this work has been awarded.
Who is the instructing authority to you?
The chief construction engineer.
Can you call him to appear before me and explain that what it is?
Baleswar, my lord, evening Baleswar.
Come, huh?
The chief construction engineer is
How much time will it take to embark journey?
In Baleswar.
Baleswar.
How much time? 3 hours,
It takes
4 hours.
4 hours. It's not 4 hours.
Maybe
Can he appear virtually?
I'll just ask him on this.
Tell him to appear virtually. At 12 noon. Just after 12 noon.
This is L3, my lords, as per my last instruction, it's L3.
That's there on record. Let's not create.
My lords,
Serial number 2, same tender notice,
second,
bid
one
capacity. They have I lottery selected. They disqualified after L1. The condition provides at the stage of combined L1, it will be evaluated. But my case, they evaluated bid capacity after one tender acceptance. The stage has already. So the same notice, same authority. They have on the gauge of bid capacity, they are choosing their own methods. That's why I'll show that. Same notice, since my learning seniors are appearing. I am also L1 lottery selected in
another repetition.
Serial number 2. Same notice, same notice, same authority, only different packages.
Yesterday he also moved, so that's why we were aware of this clause 6.
Exactly.
Because he was harping on clause 6. And then we said that
they have entered this contrary to the OPWD code. All tender notice they said at the stage of bidding, it will be bid capacity will be calculated. They have inserted first time is a combined evaluation. With this of combined evaluation, which will be taken in combined evaluation. This they have misusing colorable exercise of this combined evaluation. At the stage of evaluation, they are taking one L1 combined. Here is a case, one case they have accepted bid. After acceptance, condition provides at the stage of L1 you will evaluate it. After acceptance, they take it to as a combined evaluation. The contrary to the mandate of procedure. That is, I address
National method they have to devise to
Satisfy everyone.
Exactly. So this is a complete the only bit of it there is.
Natural licenses. Natural licenses.
Since my lord is senior is there, so I could not.
Ranganath Reddy, 19th Supreme Court.
it's in the
very
same.
reasonable. You have to be very reasonable.
Yes, my lords. My lords, I tried to understand the entire calculation in the morning. He took me with all the, I have calculation in my hand also, my lords.
Saying that really goes against the spirit of the
That minutes I will check, my lords.
7 and 8. If there is already a work awarded, then in that event there should be a contract or a agreement or a LOA must have been issued.
Yes, ma'am.
That means awarded. But if it is in contemplation of being awarded, I think that will not be
It is correct, my lords. What?
authorities may not approve or may.
That is not the case, my lords. I had
That is what
specific.
the word, I was confused with the word awarded in other tender
My lords,
notice.
I'll take in.
Awarded means 409. I was just skeptical.
My lords, I will have to take because that is what my lords, if I may be
But-
able to.
That is what we have to be really careful in
Yes, yes.
using the words and
Yes, my lords.
expressions.
Yes, my lords. That is what they had told me that is the first in this composite work. What they have done
They
is
are-
really they have given the works.
They are very educated, highly educated.
Technically
Must be
qualified.
knowing the the nuances of those words.
Technically experts.
You have to be very careful when you use every word.
Yes, my lord. Yes, my lord.
So let me come back at 12 o'clock.
Yes. Both of them.
Yes.
I have instructions, my lord, because in the first work, he has already been given the work, my lord, and LOA has already been issued in favor of the petitioner. Now, second work, they are not, because it has already, the second work has already been given to some other person, my lord.
No, when the combined evaluation made, my lord, what is the date? My lord?
You are awarded
No, my lord, this my lord, they strategically said, my lord,
That is,
my lord,
value of the work is more in the.
He's saying that if he has been chosen and work in more than one
Yes,
contract, which has different values.
Yes, ma'am.
The one which has a higher value, purposely, motivatively, and with some designs.
No, my lord, that is not the case.
You have
That was-
avoided to award
No, my
that
lord.
contract, and you awarded this smaller one. This one is
The difference is one is 6 crore and another is 5 crore work, my lords. Yes, ma'am, I understand. But first, it was the work which was given to the petitioner first, that was opened first, my lords. And according
no, same day, my lord, my lord, annexed the price.
same day, one after another. That
No, no,
and
same
first
day.
it work was given to the petitioner and second work was given to somebody else, my lords.
It will come at 12. That's
Combined.
Item number 3.
Item 3, my lord. The auction notice was issued on 23rd 1/2026. That was a holiday. And without giving up opportunity of here participation to the
Yes,
public.
yesterday.
Oh, this was the 23rd, 27th.
Yes, sir. My lords have obtained instructions. My lords may see. My lords, let me place the instructions. My lord, on 18th of January, my lord, materials were seized. Then, my lord, on 20th of January, my lord, public notice was issued, my lord, inviting general public if anybody wants to claim the seized materials. Nobody came forward to claim, my lords. Then, my lord, on 23rd, my lord, the first auction notice was issued, my lords. I will, my lord. That the auction notice, the public notice was issued on 23rd, fixing the date of auction to 24th, which was a public holiday. Therefore, my lord, because 24th, 25th, and 26th were public holidays, considering that aspect, my lord, another notice was issued on the next day, 24th, fixing the date to 27th, which was a normal day, my lord, normal working day, my lord. On 27th, my lords, 5 persons came forward and deposited bank drafts, the required security deposits, and my lord, the auction was
That you
conducted.
said on the other day as well.
Yes, my lords.
But will you go in haste if he has an account with
My lord, he has
SBI,
given a reason, my lord. My
if
lord,
he has an account with the SBI and there is
my lords, he can make a bank draft in any bank, my lord. Not required for account is not required. 5 persons gave bank drafts, my lord.
the difficulty is that are you aware of the procedures relating to a preparation of a bank draft?
Yes, my lord.
So what are the requirement of the bank draft?
My lord, it can be done in any bank, my lord.
Correct. How?
My lord,
What is to be done?
but my lord, 5
Sir,
persons.
there are two aspects. He has to go withdraw the money from his bank and then deposit with
Yes,
another
ma'am.
bank and get it. His bank is under strike. He cannot go and withdraw.
No, my lords. If my lords will see, my
Secondly,
lords.
he can issue a check. He can issue a check in favor of the other bank. That would take some time for clearance.
My lords will see
If
the
the
advisory
check
issued by
is
his
to be
bank.
cleared, thereafter.
No, my lords, not required. Not required. My lords will see the
bank draft.
My lords may see the
They will not hear this.
Now they have a multiple system.
Yes, my lords. That is what the bank also says. Annexure 6, the advisory by their own bank.
That's an automatic, the third party
Yes,
system
sir.
is there. But that also requires considerable time to get it.
That, my lords,
When
Five,
was the auction?
my lord, it was fixed to 27, my lords.
When was the auction time?
My lord, at 11:30, I believe.
11. Can it be done? Because the clearing is always done 2 hours or 3 hours in
But my lords, 5 persons have given bank drafts, my lords. And my lords may
because there was no, the difficulty is that if you have the bank account in the same bank.
No, they did not have bank accounts in the same bank, my lord.
Sir,
That also have obtained instructions.
Very easy and to get it immediately.
My lord, one submission, my lord, had he approached the mining officer, the auctioning authority,
He has
not given.
He approached you.
he has given the representation to the Tehsildar, my lord. Here the auction is being conducted by the mining officer. The mining officer had no
Who you
knowledge.
have given, mining officer or Tehsildar?
My lord, I have given the
Page 19.
Tehsildar has put the material on auction.
And here also,
Tehsildar put the material in auction or the mining officer?
mining officer.
My lord, mining auction.
So why you have not given it to
My lord, I
mining?
have given the letter to Tehsildar as well as the mining officer, my lord.
No,
Where is that you have given it?
And in
to
the
mining
letter
officer?
also, the representation also, he does not claim that defer it or allow me an opportunity. He just makes allegations against the mining officer to the Tehsildar. He has also not asked you defer
Why
it.
you have not approached the mining officer then and there and say that please give me an opportunity, hold it tomorrow, I will
Yeah.
deposit. Or permit me to participate, I will deposit.
Yes, my lord.
immediately
My lord,
tomorrow.
I have mentioned, my lord,
Where mining officer who was conducting the auction.
my lord, the Tehsildar.
Sir, you have to raise then and there. And this is what the difficulty is. I am very much interested to participate. I cannot deposit fees. Please defer it or permit me to participate, giving me exemption. I can appreciate it on that ground. Could you have approached the wrong authority? That's a Tehsildar. No, you can't. Tehsildar was not holding the auction.
Mining.
My lord, Tehsildar, in presence of the Tehsildar, auction was made. In presence of the Tehsildar, my lord. This is the rule, my lord. In presence of the Tehsildar, auction will be made.
Tehsildar is no more than market.
Only the
Empowered.
No, sir.
Exactly.
Nothing. All power has been taken away. I think 2021.
22. 22, my lord.
22. So,
My lord, the interesting case is that, my lord, they have auction, put the matter on auction on 23rd. The auction notice was issued.
we noticed, but this is what not the way. You have not gone there and protested in that.
My lord, on that day, on the same day, I have
You
removed.
have approached the wrong authority, sir. Tehsildar, not the mining officer. Then
Page number 21.
so
My lord, on the same day, under annexure 5, I have also wrote the letter and sought for documents from the mining officer, my lord.
Do you have any proof that you have
Annexure 5. The attachments.
This is after the auction, my lord. He asks for some documents.
what is this?
I have sought for the documents from the mining
Those
officer.
that you have approached on 27th.
No,
this is the 29.
Then,
clearly stated, I have not
At the
asked.
bottom left hand side.
no, that is 29.
So after that,
This is my lord.
so the RTI application. What?
I clearly stated, the auction was conducted behind my back, my lord, without giving an
Behind your
auction.
back, sir. It was in front of you. Otherwise, how would you have given the letter? It was being conducted in front of you. Since you were disqualified, not permitted to participate. That is what is there.
My lord,
That was there.
my lord, on 24th, they have stated the auction will be made on the spot. But on 27th, they have not made the auction at the spot, my lord.
Where they made.
At the office, my lord.
True. So you were there on 27th.
So when the scheduler has the venue has says, he has to inform, no notice, nothing.
You were there, otherwise how you have written a letter to Tehsildar? You are aware that this auction is being held at the office. Okay, you now take a different view. I don't think.
They are also not calculated. What needed anything? And also I am ready to pay more amount by law, the option amount by law.
So, tomorrow the another person will come and say that he will pay more whatever quoted.
And as per the rules by law, 7 days notice is minimum requirement by law. As per section 47 of the Odisha mining rules by law.
Was. Let us go by the law. They have infringed the law. Which one? Then we can.
And this is the rules by law, Gazette Publication.
I am
47. Rules 27 of Odisha mining. Of Odisha, this minor minerals.
27 relates to
Concession
lease, grant of lease.
or let me consider which rules I am unable to.
My love, Odisha mining mineral concession rules 26.
2016.
16.
27. Yes, sir.
This is applicable for grant of query. My lord, here is this case.
And it is a related to query.
Normal.
So in provision which is restricted to a specified category,
Right.
you will apply that in a general sense.
As per option is here in this case, my lord, section 40, rule 48 is applicable. 48. Disposal of minor minerals.
Yes.
Any minor minerals owned illegally
Uh,
and seized or deemed to be property of the government after the expiry of the termination of proceedings.
It says disposed of through a public auction.
Through a public
auction, including e-auctions by the authority competent for grant of public as specified in Schedule 4
Yes.
as a mining officer. And in accordance with the provision of the Indian Criminal Code, this code is provision.
The penalty is, my lord, 51. 51(4), 51(6), VI. If no person claims the minor minerals of the property, if so seized within a period of 30 days, the authority competent to compound the offence may confiscate the same to the state and dispose of the same through public auction. Well, here is the time given to the public is less than 7 days, my lord. And that has not been a confiscation to the state. Unless the property is taken to be possession of by the state, how he sold out the property by public auction? What is the confiscation? Without possession of the property, how the government has auctioned the property?
Is relatable to a jurisdictional court.
Madam.
So how the authorities are bound by it.
Madam,
If they have filed an FIR, if they have initiated a criminal proceedings, then in that event they have to, because it's a compounding of an offense. If somebody comes and claims the compounding of an offense, then in that event it will.
my lord, it's 54. But 56 is concerned, as per 56, VI. May confiscate the same to the state and dispose of the same through public.
Sir, what are you talking about this? We have already held that this clause 51 relating to penalties are applicable only in case when the FIR is lost and the matter is before the jurisdictional court. It is the jurisdictional court who has the power to do whatever is provided in Rule 51. So they are not supposed to, they are not guided or bound by that. What you say is 48, correct, because that is with the government.
As per e-auction, it is minimum 7 days notice is required by the mandatory.
Where is that 7 days?
Madam, let me permit to one time.
No, sir. We have given you enough time to study. Whenever we are putting a question, you are asking for it.
My lord, here in this case, without giving any
Whatever, every opportunity was given. This
my lord, 27 they have
a disgruntled litigant
It's a covered matter.
No, it's a covered
If you are
matter.
coming, then not covered matter. Otherwise, you would not have been engaged.
It's,
Your senior was completed.
I have three, points in this, The first one is multiple years, which your lordships have already scaled.
But I wanted one matter,
That's it.
one of the matter
In the
of
main-
multiple years or something, please come. We
In the-
want to decide it.
in the main-
That's for, we can't keep all those matters unnecessarily. Item number 45 is there. But can we fix, you just tell us a date so that we can fix a date and on that day.
Yeah, none of the
Council, Army Council.
Option is fine.
No.
Please counter 5. Counter 5.
45.
Today 45 one item is there.
One this number is
45. Item number 45 says, who is the petitioner in 45?
the single matter.
That's a 5 matter.
That's matter.
In one of that matter, I have filed that.
That's
They're not
No, I
circulated. They're not circulated the copy.
now, are you adopting that counter for the purpose of others?
Yes, yes.
Then sir copies.
2 days. In the course of day.
And we will permit only 2 councils to argue for the petitioners and only 1 or 2 councils for the. Mr. Mishra is always very energetic. He will definitely intervene.
I'm not a party to this.
Uh,
He will take the, I'm not a party to this thing. Because all these are the central.
Because he is representing the central or state?
Central.
Central. So
I'm for the state.
yes, state. So he will definitely.
Yes, yes.
Even if you are appearing for.
No, I'm in fact putting the election.
And
That's why 2, choose amongst yourself 2, and choose amongst yourself 2.
Yes, yes.
until 246
In fact, we'll be informing our other friends, who have cases, so that they'll be also present. Because only 5 cases.
If there is any peculiarity in the facts, that small write-up of the peculiarity has to be given. Because the larger issue is that whether they are permitted to issue a single notice for a multiple financial years. That has to be answered. So if it is answered in favor of the petitioners or SSCs, then naturally the consequence will follow. And if it is answered against the SSC, then naturally the other issues will be involved relating to the demand on an order. That's why I wanted a small write-up to be prepared by all of them on those aspects.
There are some matter lordships also. I am appearing in that same issue. I mean, permitted to also submit my.
I do not know. You are all appealing for the authorities. Choose among yourself 2 persons you are.
I'll submit that note, my lords. Your lordships directed at the
No, multiple notes will create a more confusion. So it will be a 1 note from the respondent side. You are all representing the same parties.
Yes.
So it should be a 1 common note.
Yes.
And there will be from their end, it should. So when
other matters.
From that, it was there in lordship on 5th, since bench did not function, that has gone out of the list.
I am just wanting a particular date fixed so that from morning this matter will be taken.
As a lordship directed, in one of the cases, convenience compilation has been filed.
No, that will compile.
Yes, Your Lordship.
How do we cope? 16th of April.
Another sister's matter is now there on board.
You want on 16th? I can do it on 16th. If all of you agree. Any difficulty? Yes?
After vacation. After vacation.
No. Before. No, sir. Before.
I can.
Before. Oh, yes, my brother, I am also agreeable. If all you agree, we can fix up 1 Saturday.
Yes.
Yes. This matter would only be listed on Saturday and we'll hear.
Is still being debated.
Subject to seniors agreeing, my lords,
Saturdays are being
I'll
debated.
be able to come physically, my lords, and assist your lordships.
Working Saturdays are still being debated also.
No, it's not. This for a special matter.
Because there are multiple councils and the difficulty is then when there are large number of cases together. In one of the matters, some councils are not there, so they wanted, so hearing is a very arduous, I would say, humongous task for the bench to conclude. So Saturday, there is no escape that there is in me another cause. Maybe in another state or a city, that is a different task.
May I just make a humble friend? Let my learned friend, Mr. Ranklagri, circulate the counters. Then at least among
16th,
these,
then we are fixing. 16th is a day for taxation.
Yes, ma'am.
Do one thing on that day. These are the certain covered matters are there. So we just simply keep those matters first and then this matter.
Maybe furnish the list of other matters of the same issue so that it can be taken up on the same day, my lords.
It will follow, don't worry about it. That's why we are give the names of you are the best person or you are the best person. Give all the matters. Because the petitions are different, so they may not know. But you people are engaged in all such matters. Give that. Today 45 is matters there. Today 45 is matters. So let it be fixed on 16, Mr. Kaur.
Yes, sir.
So these are in a copy in advance.
we can,
You also come on 16, but shows whether you will argue, Mr. Mishra will argue, or Mr.
As your lordship.
Or Mr. Kedia, whoever, I do not know.
There is a special requisition. So, for Mr. Ardu.
Yes.
No, item 6 is their D number. Yesterday it was there.
Item 16, my lord, item 16 and 37. I'm for the respondent in that matter.
Yes, wait.
That is also same issue, my lord. So the
We have
consolidated.
not called, let us see, then we can.
so first,
Keep it on 16.
apart from multiple years, there's a question of pecuniary jurisdiction.
Pecuniary jurisdiction question. Consider, don't worry.
So your lordship may admit this on multiple years, then the other points may be left open to be
It is made clear that all other points that is. I prefer union of India. Please stop with this. 6, who is appearing, sir?
What is his name?
Chief Construction Engineer, Rural
Construction engineer.
Section.
Management. You have not saved his name.
He's not responding.
Sir,
Yes.
Respected sir,
Yes, now tell me that you have handed over the method of calculation of a bid capacity. It appears to us that there is some kind of a confusion or ambiguity as the petitioner, according to the formula given in clause 7 of your tender document, is saying that you have taken a wrong one. How can the bid capacity varies for each item? It should be static one.
sir.
What is the modalities of this formula? How you have arrived at the formula so far as one of the bidder, that is, what is his name?
Number 7, Krishna Mahapatra.
Krishna Mahapatra. You
Sir.
have assessed his bid capacity in three different or 4 different items in a different manner. How can it go in a different manner?
Sir, bid capacity of Sri Pragyanandan Krishna Mahapatra, the bid capacity formula is A into A.
I have seen A into 1 into 2 minus B, that is there in the formula, I know.
Yes.
But if you come to page 174,
174.
do you have the copy
Writ petition.
of the writ petition?
Sir.
If you come to 174,
1 second.
So put a microphone to Madam was.
Sir,
this is a Sukumar Midya. 174.
Your Lordship, this is first lowest bidder, Krishna Mahapatra, fourth line in para 1 itself.
Where?
Lord, please report, then kindly see.
Yes.
Now, first lowest bidder, Krishna Mahapatra, has been disqualified in combined evaluation due to insufficient bid capacity.
Yes. So,
And the estimated value is 3.90, estimated value is 3.92, and his bid capacity as per my work is 5.30. Then he qualified. If it is 3.92, 5.30, how is it not qualifying? That means prevaricating methods of calculation.
they have given a calculation that his bid capacity is 3.90.
Estimated value, 3.9.
Estimated.
Yes, estimated value.
Then
3.9.
in all the contract, it should be the same, 3.90. How it has become 9.4? How it becomes 9.4, which you have given a calculation to your counsel, additional government advocate. What is the manner in which you have arrived this? Tell us, sir.
Sir, the bid capacity of the Krishna Mahapatra 940.68.
Correct.
One word. That name is RT Road.
Now, if it is 940, then
Yes.
clause 6 of the tender document says that if he is L1 in multiple bids,
Yes, sir.
correct? Then the combined evaluation will be done
Yes, sir.
to decide the number of works to be awarded to him.
Yes, sir.
The authority reserves the right to accept one or more number of works depending on a technical qualification.
Yes, sir.
Correct. So bid capacity, if it is a combined manner, it has to be evaluated. Then he is having a bid capacity of 940.68.
Yes, sir.
Correct. If the bid capacity at page 174 is 3.92,
Yes, sir.
then if he multiple, then he is still within 9.40. He can be awarded contracts.
Sir, another one.
How can he say that you have insufficient bid capacity?
Sir, excuse me, sir. Total 940 the bid capacity.
Correct.
One in another NCB number 39 awarded to Sri Krishna Mahapatra 17/2026 409.
This work has already been awarded to him. He awarded that work. Tell me, whether LOA is issued to him, Krishna, for 409.82. It has been awarded.
Yes, sir. Yes, sir. Accepted by.
LOA is issued.
Yes, sir.
LOA is issued.
Letter of acceptance already issued by the tender evaluating authority.
For this 409,
Sir. Sir.
for 409 lakhs,
Yes, sir.
the work has been, letter of acceptance has been issued to him.
Yes, sir. Yes, sir.
When prior to the opening of the bid or prior to the submission of the bid?
Sir, not. Huh?
On 17/1/2026,
After
it has been awarded.
evaluation of other 3 works, this work 409 already accepted by the tender inviting authority on dated 17/8/26 of NCB 39 or another NCB.
NCB is different.
Yes, sir. Yes, sir.
In this NCB, item number 39, is a different tender or the same tender?
Different tender, sir. Different tender.
Different tender, 409. So you have already awarded.
Yes, sir.
When you awarded, prior to the submission of the bid in the instant tender or after?
He said after. The 9/12 is the opening. I'm so sorry.
17.
Tell me,
Sir,
this work of 409.82 is awarded to Krishna prior to the last date of submission of this bid or after the last date of submission of this bid?
after, sir.
After that. But before the opening of the bid, what?
Sir.
Before or after the opening of the bid?
Sir,
Why we are asking the question? Because in clause 7 you have said that he must have the bid capacity at the expected time of bidding.
sir.
What is the expected time of bidding? Is it the last day of submission of the bid, which is the expected time of bidding, or it is the time when the technical evaluation is done, or at the time when the financial bid is open? What is the expected time of bidding? What you have done?
Sir, last date of bill, dropping of a BD.
Correct. So that is the day. And this work of 409 is, according to you, awarded after the last date of bidding in this contract.
Yes,
So
sir.
can you take into account this 409?
Yes, sir. Yes, sir.
How can you sir, bid capacity on the date of filing the bid or before submitting the bid?
Sir.
Up to that, whatever he has the work in his hand, you will take into consideration not thereafter. Can you take thereafter?
Sir,
I think you should talk to him in vernacular language. He understands better than. I think he has jumbled up. Please talk that in that. He's admitting after.
No, that's what he's trying to say, Malaj. If I may just clarify, Malaj. In the combined evaluation sheet, if we go, Malaj, 940 is the bid capacity. Yes, Malaj, this 409 work has been awarded.
When? That is the main criteria. When he says that after the submission of the bid.
Everything in the last page, what they have done is mentioned in the last page. Malaj, if I may just read that one page, Malaj. The work at serial number 1, that is construction of road from RD so-and-so, Ranjanagar Bhadra so-and-so, has been awarded to Krishna Mohapatra.
Yes.
Krishna Mohapatra on 17/1/2026.
What was the last date of submission of the bid?
Last date of submission of the bid was 6/12, 9/12.
Of 2025.
2025.
So this is after. Admitted.
Yes.
Let us see. Then we'll go into the interpretative tools.
Yes, ma'am.
Admitted position after.
Yes, ma'am. That was opened first, that was given to him, my judge. That first bid was opened first and it was given to him because he had the bid capacity, my judge. Second, my judge, balance bid capacity is 530. Why, my judge? Why I say this? If we refer to my page number 55, what they say, also again technically they have to evaluate. Because if they give the work, another work to same person, they should know that whether they have that bid capacity to complete the work. And hence, this is the reason, my lords. Balance bid capacity of Sri Mahapatra is 530, my lords. The bid capacity of Krishna Mahapatra is insufficient to meet the required bid capacity in aggregate of other three, the table which is there, my lords. Hence, he is eligible to award any one of the above work from serial 2 to 4. As per the decision of the tender committee, the work serial number 2, the question, and the work in question, my lords, in the district of Bhadrak so-and-so may be awarded in favor of Sri Krishna Mahapatra as the other L1 bidder, Sri so-and-so has insufficient bid capacity in combined evaluation. Hence, work number 2 in the box was given to him because it was 14.99% less, my lord. And in that case, the L1.
Sir, the main question is that what would be the absolutely a magical date of evaluating a composite bid capacity?
That is not there in the contract.
This is not then the estimated time of bidding. When the word bidding is used, what does it mean?
That means that is why 940 has been taken into consideration.
So can I take or derive an inspiration from your argument that the time of bidding or estimated time of bidding, or let us confine to bidding, is a wider connotation? It means from not only the last date of submission of the bid, but also the opening of the bid, also the evaluation of the bid at the technical, as well as involves the opening of the financial bid. So it is all the bid. It's a bidding is a very wide one. All the stages are included within it. And then capacity is to be there. Then what will happen? That if eligibility is also to be considered, then the eligibility, according to you, should be considered at the time of bidding. Means even at the time of final financial stage, the eligibility is remained open and it is to be considered.
The bid capacity is 940 megawatts. Bid capacity is 940, that we have to keep in our mind, megawatts. That is as per expected date of bidding, megawatts, that is 940, which is taken into consideration. The first work, 409, was given to him on 17/1/2026. And megawatts, I will fall back to.
I understand. Then you stick to 940. Then you stick to 940. Then your document at page 174 appears to be a wrong one. Because you could say that since he has already been awarded one contract, in terms of this, it is a discretion left to the authority to award one or more contract. I am not giving, I am giving him one contract only. But you cannot say insufficient.
No, I'll fall back. What I am falling back is page 55 to subclause 6. I'll just read this once more. In case if any bidder stands lowest in multiple bids, here this is the case, method. Combined evaluation will be done to decide the number of work to be awarded to him. It can be more than one. The authority reserves the right to reject more than accept one or more number of works depending on the technical qualification. Why, my lords, I am referring to technical qualification. Once 409 work has been given, that amount will be deducted.
Sir, 174 has to be, this is again I'm saying, technical qualification stands on a different footing.
That is what is mentioned, my lords.
Sir, madam, when you use the word technical qualification, there are two aspects. One is a person must have been technically qualified, and second is a person must have a financial capacity or financially qualified. These are the two different expressions which are used in a tender. You cannot jumble up. Technically, you can say that though he is declared as L1, but in this contract, I do not find that he has any technical qualification to execute the work, despite having a financial capacity to do the work.
Technical qualification includes bid capacity.
Very interesting.
Yes, my lords.
Very interesting.
Criteria, my lords, and that is the
Is it defined? The technical qualification is defined in the tender?
My lord,
Any expressions used in the tender is defined?
eligibility criteria, my lord. Eligibility criteria, the bid capacity is included. This is the uniform. Page
Where?
55. This is the uniform method in which they have done, my lords. In this item number 2, my lords, also, why the second work was not given to the client of Mr. Prabodh sir is because in the second matter, this bid capacity had fallen short.
Tobacco-wise, probably I'm breaking my head to a rock solid eyes, unable to comprehend what you say. When you use the word technical qualification or a technical aspect, does it encompasses within itself the financial
The technical, yes, my lords. My answer is yes. Technical.
Show us. Then why the tenders are divided? Why the tenders are divided into two stages?
Second is the financial bid, my lords. That is the amount.
The financial capacity also has to. Yes, I understood what you want to say. Where is the definition?
And page number 55 talks about eligibility criteria, within which the bid capacity is included. My lord.
Page
55, my lord.
To that extent, she is correct because a person must have.
Let us decide.
Yes,
I
my lord.
don't think so that what we say is correct way of interpreting.
My lords, one more judgment to fall back, my lords.
Even
My lords, the interpretation of the tender is best judged is the tender inviting authority, my lords. And here there is no case of perversity or arbitrariness or malafide. In all cases, the same formula has been adopted.
I know that we have also delivered a judgment.
I'm giving you that.
That is the author,
Yes,
is an author who is the best person to understand. That's not what they are looking.
Yes, my lord, because item number 1 and 2, similar method was adopted, my lord.
Vedika resources, madam. On your lordship judgment following number of citations. These are the,
I'll take out print of my
but
lord.
give us 2 copies.
What is there?
Vedika resources, my lord, lordship will find para 7 and 8.
That is.
BSN Joshi, Boxy Security, your lordship has referred to all those judgments, my lord. Jagdish Mandal.
We know our limitations into this.
Para 7 and 8. Lordship will straightway find para phase 13, your lordship referred to here, Boxy Security. Then BSN Joshi, para 7.3.
Yes, we have seen that. We remember when we fitted to that.
Right, sir. And Vedika resources, I mean, all other judgments are following this judgment, your lordship judgment, I say. But this encyclopedia of this eligibility clause, lordship has interpreted it clearly. And essential term.
Same.
Yes, my lord, and my lord, one judgment of Honorable Supreme Court, my lord, in Angam at India versus, my lord, I don't have the copy, my lord, I have it.
What is the name?
It's AGMATEL, India Private Limited versus Resources Telecom and others. My lord, I have been in the, yes, my lord. My lord, para 17, my lord. I'll just read, my lord, the relevant paragraph, my lord, allow me. My lords, I have the live law, my lords, actually. Live law citation.
Live law.
That's only because of the paucity of time I just took out the judgment, my lords. I take out the Supreme Court version also, my lords. If I may be permitted to read few paragraphs.
What is
my lords, I'll just read the few paragraphs, my lords. Here, my lords, the issue was how the interpretation of tender documents relevant principles were dealt, my lords.
Yes.
Para 16 talks of scope of judicial review.
The date of.
Yes, my lords. It is
2022.
2022 live law Supreme Court 10.
Resources telecom.
Yes, my lords. Yes, my lords.
Admitted in your
Admitted, my lords. Para, yes, my lords. Para 16 onwards, my lords.
Para
16 onwards.
3.
Yes, my lords.
Okay.
Further and distant judgment.
Shilpi also, my lords, talks about
Para 16 begins with
the scope of judicial review in contractual matters and more particularly in relation of interpretation of tender documents.
All have been considered. So all is, we have also, we are aware, AFCON we have considered it. I know AFCON principles.
Galaxy.
Galaxy, yes, my lords. Considering that only, my lords.
We have taken into consideration, we'll take another into consideration.
Yes, my lords. In this matter, the High Court, the Honorable High Court, had interfered in the technical evaluation in that matter, my lords, and had interpreted in one manner and had quashed the technical evaluation, my lords. That was challenged, and in those terms, learned Honorable Supreme Court in para 7.
Madam, here conscious.
Yes, ma'am.
Law is well settled.
Yes, ma'am.
If the particular language used in the tender document is capable of being interpreted or applied more than one manner, then the manner chosen by the authorities does not invite any interference, even if the court feels that the other manner is more appropriate. The court will not substitute. But if the court finds that the interpretation is absolutely beyond any conceivable human mind, and no reasonable man would understand the language in such fashion, will the court be a mute spectator simply going by the ipse dixit of the authorities' mandate? No.
No, my lords.
These decisions are that if the authorities who may be author of the tender document, if they have interpreted differently, and it appears from the document that they are applying a different standard or a method of calculation for a different parties, that also is one of the ground the court will definitely look into this matter, and how far the court will interfere with the writ. Let us listen.
Yes, my lords. Only
And you have the avenues to explore.
yes, my lords. My lords.
Well,
Only
relating this paragraph from CP, the authority which floats the contract or tender and has authored the tender documents is the best judge as to how the documents have to be interpreted. If two interpretations are possible,
This is what I am saying.
interpretation of author must be accepted. Thereafter, the courts will only interfere to prevent arbitrariness, irrationality, bias, malpractice, or publicity.
yes, my lords. Here I wanted
Yes.
my lords one line, my lords.
That's always there.
My lords, I understand, my
But
lords.
I have said so. That is what is the
Yes, my lord.
reflection in
No,
the
my lord.
judgment.
To answer that, that is what I was trying to say, my lords.
You will answer.
There is no irrationality. There is no irrationality or
Let us see
unreasonableness
that
because
whether you have correctly understood the language, you have correctly applied uniformly without any, keep it for others.
it's only one submission, if I may be permitted, my lords. Only irrationality here, my lords, that it's only to answer that question, my lords, whether it's financial bid and technical evaluation, what are the different, that is at page number 49, my lords. What is technical evaluation and what is financial bid?
We say the issue is one. Or others.
Nine. Nine.
Yes.
That is 2025. This is online, page 232. Supreme Court, recent judgment. But Justice Srikanth and Justice Judgment. Patina Campbell Club Private Limited versus. I'll please short note from the demand, please.
Both the matters.
Both of this.
The petitioner challenges the order passed by the Commissioner of GST and Commissioner of CT and GST Authority is an appellate authority under Section 18, subsection 5, clause B of the Entity Tax Act, your lordships, upholding the order of the revisional authority under Section 1 of Section 18, imposing a penalty under Section 9C5 of the Act.
There is no further remedy by way of.
No, my lord, there is no further remedy with appellate lordships. So the improvement order has been passed by my lord's lordship, ignoring the direction of this honorable court in WPH number 1417 of 2018, your lordships.
What is that?
That is the direction was there. Well,
You have the.
yes, my lord.
Copy.
Yes, my lord.
Which key?
That is a voluminous one of the separate.
Yes. What was the direction?
Madam, I can go to the last page, your lordships. Page number 71, para 17.3, my lord. Last page, my lord.
Assessment.
My lord.
Penalty from assessment under section 9C.
So my lord, audit asset under 9C was
There was
passed.
a mandatory penalty.
There is a mandatory penalty, but the assessing of not impose a penalty is because there is no
Committee decision.
yes, my lords.
No.
But on revision, your lordships, the order passed
So
by
the decision was taken.
so it was taken by the additional commissioner, my lords, without jurisdiction. My lord, the order passed by self-satisfaction will be reviewed by the joint commissioner instead of that will be reviewed by the additional commissioner.
Error of jurisdiction.
Commissioner has confirmed in appeal.
Yes, so far as strikes at the root.
But that Mahara supply is applicable.
And your commissioner
Yeah, let's see, patch.
assured this court
Yeah, let's see, let one.
as a recall.
Next week, we are keeping it as Wednesday.
This judgment is not applicable. What my lord.
No.
Yeah, let's see, that part.
Yeah.
That part I have to consider.
Committee which is constituted
No.
says will not insist for a penalty because of the reason is.
He is not in that group. He is not in that.
The act was rather challenged at that point of time.
At that point of time, who were all there?
No, Honorable Supreme Court's interim order of 2010. Your let's see, I can.
Paragraph 30 of the Reliance judgment was if he comes, then he is entitled to
He has not come.
who will come.
I was facing, I know.
This time let me.
So far as the jurisdiction, so far as your lordship, so far as the jurisdiction is concerned, I have to concede on that issue.
Item number 2.
But so far as the merit I have to ask.
See, if it is there, it's there.
Item 2.
Give it.
Right.
You can use it in another code.
It is
He has a strong point so far as the jurisdiction.
item 2, sir.
Delegates power, then he is sitting in
But that can be. Your lordship, only deputy commissioner against the deputy commissioner order, additional commissioner so motor revision can be done. That's 2009 and 2010 notification. And 2018 notification, as your lordship knows very well, that has not been gazetted and I know your lordship will object that.
How could your commission do this? As necessarily applied to the
That was prior to 2009.
Proceeding on the question.
Item 2, sir.
Original order has been.
Melody challenges 73. Here, the dispute is that copy name and
What do you want to give it a copy?
I saw that.
He misplaced someone else requested.
When he has requested, then why you, have you requested earlier?
No, today only.
Give him a copy.
Okay.
Douglas. He is named here, here's on the stop of the.
senior standing.
I am putting the
We are to serve the copy.
Yes.
Item number 3.
Let me. Next one is not there. I will not avail.
There are
2nd April.
2nd April?
Item number 3.
April 73 or 74?
79 minutes. Mine only period delegate to GST article.
Item number 4.
Legal losses. Sections 74 losses in 20 term. I was the same ones.
Item number 5.
I was the same ones.
Item number 6.
Finding of facts. The question of the major part has been allowed. And this is the finding of fact and tribunal is being the last fact finding of the.
there must be question of law, otherwise
Again.
Mr. Das is in books of books, so not out such as.
The additional tax has been determined, your lordships, on the basis of suppression sales of 2.97 lakhs.
On the basis of?
Suppression of sales of 2.97 crore lakhs. On comparison of the book profit with the books of account, your lordships. Lordship, kindly glance to page number 23, your lordships.
Yes.
Page 23 is your lordships, page 1. The opening balance 8 and 1st April 2011 nil. Yes, my lord. Purchase during the relevant period on audit 231 crores, your lordships. Total purchase effected, your lordship, 231 crores.
Same, it should be same. Yes.
The less of the closing stock on 31st of March 2013, 10 crores, your lordships. Purchase value of sales arrived at 2.21 crores, your lordships. And gross profit margin of 5.47. as per profit loss account of 1213, amounting to rupees 12 crores rupees, assumed sale, your lordships, derived with 233 crores, and the actual share disclosed 230 crores. So there is a deficient 2.9, which is determined as a suppression of sales, your lordships. Without any iota of evidences, the goods are home to sold, the way of recovery, the mode of receipt of payment, and not an allegation that goods have been, there is no whisper of the goods have been sold. Only on the basis of books of account.
This emanates from 42.
Yes, my friend.
This assessment emanates from
42.
audit assessment.
Audit assessment.
Audit assessment of 40.
The beer is required.
Article 43 would have.
And the question of play, my lord, is page 11, my lords.
Then first appeal and second appeal.
First appeal authority has reduced the amount, your lordship. Yes, my lord. Determine the rate of profit margin of each year. Calculate at the rate of 4.17 for the 11-12 and 12-13 for the
Figures are not changed.
No, my lord.
Figures are not changed.
Yes, my lord.
No, first appeal has been allowed on other ground.
No, I'm not that. So I'm only limited ground with the suppression of sales, your lordships.
The tribunal is page 45. Page
45, my lords, para 9, your lordships.
The page 45, paragraph 9 is on this issue. In 8, last part that has been allowed, the major part.
May I read out, my lords?
Finding on that.
He has confirmed the assessment.
With regard to that profit margin, what is this finding? Has proceeded on a different footing. Whether VAT is to be charged first, then entry tax or entry tax.
That has been allowed. That has been allowed. That issue is not here. That tribunal has allowed.
I am on page 45.
He is not here.
Para 9, my lord. With regard to this issue, concern sense of patient, your lords.
Paragraph 9.
Other points.
Right.
Finding of fact is not.
First appellate,
Saying that
first appellate authority observation is page 37.
No, tribunal has to independently apply its mind. It has simply gone into assessment order.
Page 37 is the first appellate authority's finding. Page 37 similarly.
No, this 40, 45 you are talking about.
My lord.
Not justify. You could not justify. That is finding.
Yes, my lords. My lords, there is no any other than the comparison statement, your lordships. There is no other evidences out of it is important report, my lords.
You have procured the goods from one company, that company. It is reflected.
No, my lord, there are number as per my knowledge, there are number of companies also lordships.
These are the finding of facts. These are finding of facts. Then why we admit on a substantive question of law?
My lord, similar issue already been admitted by my lords, your lordships.
That is a very question of law, not substantial question.
Police role that it essentially said.
It is substantial question of law. It is substantial question of law, not question of subsection 2,
Section 18.
and
Section petition shall be in the memorandum of appeal by stating substantial question of law, but one question or any question of law, substantial question.
one is any question.
Again.
That essentially is the question of owners. That cannot be said to be a substantial question of law in the essence. You are talking about that if they are treating a particular sale, that there should be an actual the materials which should be there that you have sold it. Unexplained. Stock, shortage of stock. So, how it will come?
Let me put the question. Give another
Both the authorities have factually found say that is why what High Court will admit the concurrent finding of fact.
That the findings will also just unless
Paragraph 9 I have read.
paragraph 7 you lordships.
Paragraph 7 has been allowed as it says that whether you should charge the entry tax first before the VAT is calculated or a VAT first before the entry tax.
Yes, fine.
All these questions he says that
It is a question of law. That can be a question of it.
you are not agreed by that. You are simply agreed by that portion of the separation of the actual sale. So that is what the concrete finding has come.
But there is a finding that is that there is a judgment order is valid structure unless the department is further able to show that the surplus stock was sold by the assessee, then cannot be an automatic enhancement of the sold turnover.
This is essentially a question of fact. It's a question of owners. It is the owners of the department to prove that it has been actually sold. Owners become relatively may have a blending of question of law, but not a substantial question of.
Let me ponder on this way also. Can you give a statement?
We have already held distinction between a question of law and a substantial question.
Let me make a research on this.
Do it, read
This my
Dhulabai's judgment of the Supreme Court to Sarkar Sajani can be subsequent to answer.
But
RC cancellation matters. Base of business is the issue. And you are filing HARISH.
I have to call for an inquiry report. I have to call for an inquiry report. Your Lordship, please submitting on additional evidences. Your Lordship, I kindly looked into the input order. Page 12, page 11.
Your Lordship. So we are saying that let it be re-verified. We are giving proof that we are conducting business at all that place. So let
me call for an inquiry report. And since it is month of March, Your Lordship,
One is accepted in the plea. Copy.
Order cancelling the registry.
The 17.7 minutes.
Where is that?
That is, my lord, your lordship, and there it's not been quoted, your lordship, kindly input. Huh? Take it on step. Your lordship, kindly refer to 17 number. Let us place it, minutes. Where a dealer or person has preferred an appeal.
No, I have read it.
I support that.
So, Milods, the commission of this
This appears to be, if the only ground of rejection is that since you have already approached the appellate forum, you'll appeal it separately. So there is no question of drafting any stay. When the subsection 7 of section 17 empower you to grant, and grant when
Independence.
independence is. So is that being the position that the situation is a absolutely ideal exercise? He has to, he or she has to go into the merit. It says either full or in part.
It can't
be
zero. Your Lordship, here some reasonings are there. But in that case, Your Lordship, the undersigned. Your Lordship, the undersigned.
The paragraph page 24 contains the reasoning, paragraph 5.
Yes.
Tell me what are the reasons, read it.
Your Lordship, on examination, it is observed the issue involved in the instant case relate to less payment of admitted tax, non-payment of entry tax on the scheduled goods.
These are the reflection of the fact. No finding.
Your Lordship.
The case involved these.
Your Lordship,
no problem.
For that reason, Your Lordship, on the last occasion also, I have requested, I paid Your Lordship. Your Lordship may fix a percentage.
See, Guru, there was absence of dealer in spite of the notices, and he could not furnish certain statements to justify his sale on C form.
Your Lordship.
So that was the content. That was the situation there.
Well,
here it is SCZ. Are you disposed?
Not letting the commissioner's order, entire order, Your Lordship may kindly peruse. Nowhere it has been admitted what my Lord and Senior has submitted. Not a single document in the.
Your Lordship may kindly.
Please read the nature of the.
Your Lordship.
Is it a proper exercise of R under subsection 7?
Your Lordship, as I'm appearing before Your Lordship.
Decide it afresh. Let him go and decide afresh. Yes, the instant repetition that will be instant the legislature.
Still, may I pardon to make a small mention in my matter which your lordship has reserved order. If it comes on to be mentioned, same thing will also. No reason, nothing else, then the matter is pending.
Sir, you already passed that day. It is not uploaded, I think, within half
I think within 15 minutes you will get the update.
I think already reserved, that is why I said.
No, it is already done.
Item 9.
May I please ask? Perception application for condonation of delay in filing audit report.
One,
Application for condonation of delay in filing audit report in Form 10D has been rejected by the Commissioner of Income Tax Exemption. So, 1192.
available or revisable order.
Your Lordship, there is a delay of 18 days. Action. Action, Mr.
Then available or revisable order.
Similar order has been passed by your Lordship.
The same number.
COVID-19.
Another small order was special.
No, there was another different order. They are trying to.
So this 1192B you have as smaller or
Sir.
then you
That goes also.
place the number.
I'll be giving within.
So this one is the first one. Lengthy one. This one I think we have referred to in your case.
Small order one. Not so large.
This judgment is referred to. Correct?
Just fine. I'll.
Give.
Next. Item 10.
Can your lordship against to face this assessment under section 151A?
You have checked the period.
No, sir. It's a next to.
Yes.
Item 11.
Item number 11 minutes, this is regarding constitutional statement. None. Please, minutes, 4 minutes.
Item 12.
GST matter because initiation of SOPA duties and your lordship's consequential access order in original your lordship in name of a direct person.
This is the petitioner has come up after the first appeal order, rejection of the first appeal order. They should under the GST Act, there is a provision. It's very provision. Under the GST Act, that was under the service tax. There is a provision under the GST. Round of delay matters.
Definitely. You go to the track.
Yes.
The capital order.
Order we shall look for.
Item 13. Limited. Item 13.
Very sorry. Is this also in the natural justice or also remanded to the hospital? The judgment is what's also delivered with judgment that is in column of security now.
It was passed during the COVID-19.
COVID-19 period, the order was passed. All the notice has been held as service, and it's also extended by the judgment of.
Yeah. Yes.
Item 16.
May it please your lordships. Lordship, 16 has 5 petitions and item 37, they are connected together, your lordships.
Yes.
Lordship, the submission in these matters is these writs are against a show cause notice, Your Lordship. Normally, Your Lordship will not interfere in a show cause notice. But in the present case, Your Lordships, the notices are expressly without jurisdiction. We have filed returns.
Without jurisdiction means issued by an authority not conferred powers under the statute.
No, Your Lordship.
Then
Deliberately
why you say
misleading.
without jurisdiction?
Your Lordship knows that. We lawyers overplay that. But what we wanted to say is limitation, Your Lordship, is also a question of jurisdiction.
Yes.
Normally, they can issue notice within 3 years. And in case of fraud, etc., they can issue notice for 5 years. That's the law. And Your Lordship, 66 Supreme Court says limitation of mention of jurisdiction.
Yes.
I filed returns claiming exemption from tax. The show cause notice says you have filed return claiming exemption from tax. That very turnover, I feel, is not eligible for exemption. Therefore, I am demanding tax. The short question, therefore, is where an assessee files returns as in the form prescribed by the rules, shows the turnover correctly, claims an exemption and mentions the exemption notification, authorities feel exemption is not available, then, Your Lordship, that cannot be case of fraud. That's the only point, and that is concluded by
That's the case of a computation of the.
Your Lordship, I make a claim to agree or disagree.
Yes.
And the law gives time for 3 years. In case of fraud, you can do for 5 years. That's expressly the problem. So, according to me, Your Lordship, my learned friend has to put in some preliminary reply at least. This is the only point. Show cause says you are claiming the return. Turnover is correct.
Where is the show cause?
Lordship, yes.
Page 66.
Lordship, yes. I want to show.
Which one is the show cause?
Your Lordship, be good enough to take item number 37. They are connected to Lordship, same party, 6703.
37.
No. Tell me in this matter.
I will take it out, Lord. Just give me 1 minute.
Which one is the show cause?
Look, page 66, it starts at 66.
Lordship.
66 and item 15. In first sub-item, page 66.
It starts at page 66, Your Lordship, but I request Your Lordship to come to page 83, PDF page, no? Page 83. Yeah, 86. This is very bad. Para 9.2.
83 is allegation.
Page 86, Your Lordship, para 9.2.
No, show cause it starts from page 66.
Lordship, yes.
Yes.
Now, Mr. Sridharan,
Please, Lordship.
tell me this show cause bears a date of 31st January 2023.
Lordship, yes.
You are coming in 2026, that is practically after 3 years from the date of the show cause.
Lordship,
Why should we interfere now? What has happened in the meantime? You must have given a reply or what?
Lordship,
You do not know.
I'm grateful to Your Lordship. I made a small mistake in projecting the matter. Under the earlier excise and service tax regime, Your Lordship, time limit is for issuing show cause. Now, under the GST, time limit is for adjudication order, like income tax. So, I could have come only now. They gave me a letter last week, about 2 weeks ago. I said, now 3 years are over, therefore adjudication cannot be done. Therefore,
let them decide. Mere issuance of the show cause notice does not mean that they have finally formed the opinion. Ultimately, they may drop the proceedings as well.
When the notice is expressly barred by, when the limitation is already expired.
Sir, this is of 2023. Now you waited for 3 years and then coming forward.
I'm sorry, Lord. I just kindly permit me to put it again.
Please.
The time limit adjudication of the matter is 3 years for the respective period. So time is proceedings are now.
Look at your prayer.
Lord, just give 1 minute. Just take out the prayer.
Immediately.
Lordship is also protecting my lords in that.
What protect? You are an adjudicating authority. What protection? You want?
I'm talking about myself in personal capacity.
No, definitely.
That's right.
Yes,
Your
this
Lordship, my Lord Justice Aram Sahai, Honorable Lord Justice Aram Sahai in the Supreme Court always used to say, heard the counsel for the revenue, matter to be not treated as part of adjourned. Because if you say simply adjourned, counsel gets 0 fee in central government.
correct.
Whatever partly some they pay also. Therefore, my Lord always used to
No,
say,
that's why we are also recording that they vehemently and
Previous matter Lordship is said that.
submitting the same, so that it will go that they have argued with all conviction.
in Bombay, Lordship, we write stand over for tomorrow. Stand over means no fee for the counsel for the revenue.
Yes, that is true. Yes, that's true. Yes.
Grateful, my Lord.
37 items.
Oh, yes, we are seeing that.
Grateful.
Yes, call the next.
Item 17.
That's
Obliged.
73 4B is the perimeter provision under Central Excise Act 11A11. And this is, I have made the correction. Lordship, no, this.
But the matter is not pending.
No, Lordship, yeah. This matter relates to fraudulence has been done by the Gupta companies and the demand has been made more than 600 crores. And there are 22 parties are involved. More than 23 parties are involved. And in this case, the 3 persons which has been involved, they have been imposed a penalty under Rule 26, 3 lakhs rupees. It's an order is an appealable. Let him file an appeal before the appellate authority. Thus, may I indicate? Firstly, the penalty imposed against me and what has happened in this case. Somebody, I am a bus operator. Somebody is taking gutka in his bag in the bus. The gutka carrier gets intercepted. My bus is intercepted. My bus is
a public bus or a private bus or what?
It's a bus.
A normal or a general public or
general.
How can you do it a private bus there?
Yes, it's owned by a private company.
Is operating on the basis of, do you have those route permits?
Yes. Everything is there. However, here the first issue that I am raising, is it is barred by limitation as per 11A11, which is the perimeteria provision. Copy, is the provision is a mirror image of 73.4B. Only thing, in 73.4B, 1 year is the maximum, 11A11 is 2 years. And this is purely beyond 2 years. The show cause notice of 2000, there are 2 show cause notices. One is 2018, the other is 2020. And this order in original is passed on December 2025. So it is well and truly beyond 2 years.
How can it be, Mr. Kedia, if he's a bus operator and he's operating under the route permit? He has no control that who is traveling the commuters. Can he check?
The bus operator was aware of all this scam. Lordship,
how do you come to a finding? This is what is the.
Your Lordship,
is all the hearsay evidence, or do you have any concrete
number 106, and in that even also in the statement they had given the recording, and Your Lordship.
Whose statement?
Of the when they put a red on this, they put a statement before the.
Who gave a statement?
The bus authority also there. One of the partner of the Dolphin bus. And Lordship, appearance notice has been also been given. Personal appearance notice has been given. Notice was given 3/11/2025 also. PH notice was given. I say that please provide me
the partner has defied you. Your partner has defied you.
No. The bus is under the ownership of Mr. Rajendra Sahu singularly.
So he says partner.
That is up to
How? If it is a individual name, what partner?
Those are
from where you got the partner concept?
Yes, those are on the factual aspect. Insofar as on the face of it, Malak will kindly see page 44. What is this order in original about? Malak will kindly see page 44. The order in original relates to 2 show cause notice.
How much you have to deposit while filing an appeal?
Only 7.5%. 3 people have been imposed penalty of 3 lakhs each, and my bus is ordered to be confiscated.
This is 7.5.
Yes.
22%.
Yes, 7.5. I'm not on that, but why should this is
Why you jump the forum?
It's clearly covered by the 734B issue.
Oh, whatever.
Kindly see this one.
The matter is pending in the Supreme Court now. So it's better you go there.
It's never given an opportunity, Milad. That's I assail this. If you're not, I'll just open my case then, Milad.
No, sir. Huh? Which one? What is this case?
Milad, what has happened, Milad? The order in original is at page 42, 10th of December 2025. Therein, Milad, 3 lakhs each has been imposed upon the petitioners, 3 petitioners, that is 9 lakhs, and it has been directed that my bus will be confiscated. The petitioner number 1 is the owner of the bus, and the bus will be confiscated. Milad will kindly see page 23, the first show cause notice that comes. The PH notice at page 20.
Yes.
Your Lordship will see the order, the PH notice date is 8th of August 2024. Personal hearing in respect of show cause cum demand notice number such and such dated 29/12/2020 to Messrs. Meena Zarda such and such. Please refer to the above mentioned SCN. In this connection, I have been directed to inform you that PH in this matter is fixed on 10/9/24 at the time mentioned in the attached list such and such. In case you have not filed any reply to the SCN, you are requested to file the same without any further delay as time has already.
So that is given.
Yes, PH notice is given. Madam will see my response.
It is given to you as well.
Yes, it is given to me. Because there is no there's no denial to that. Kindly see my response, Willis, at page 25.
Correct. That you have said that it is not.
Millad's page 25, September 5, 2024, I write to them.
You have said that it is around 4 years ago.
And I asked for their documents, the show cause notice, and they relied upon documents.
True.
Kindly see this. A notice has been issued for personal hearing by your...
No, you wanted that the so-called notice be also given and relied on documents should also be given to you. That was immediately done on 5th September 2024.
This 5th September 2024 is my mail, Millard, requesting to provide this. Now, Millard will kindly see this. Further, your good office may kindly consider that with the elapse of substantial time and also since there has been a shifting of office of the earlier conducting counsel.
No, that you have said that because of this is a very old matter. We require collection of the documents. You please supply me SCN and RUD, then I'll give you a reply. Then
Millard will kindly see page 27.
Yes, that's a letter by them.
Again, another PH notice.
1410.
Fixing it on 1410. Without Millard responding to my request.
Whatever.
Fact remains, Millard, that was never provided despite my
whatever.
Now Millard will kindly take page 32.
Yes.
On October 14, I write, I am in receipt of this. The undersigned is appearing for the following notices concerning the PH notice dated such and such. The instant notice has been issued for the personal hearing by your good office fixing the hearing for today. However, it is humbly submitted that the notice...
Again, you reiterated, please supply me those copies on 14th.
Once again, I request and I say...
Then again, the date was fixed on 3rd November.
Madam, may kindly see this. My request was September 2020.
No, I understand. Before 14th of September or 13th of September, that date was fixed. You have given on 5th.
I'm not on that. Madam, I'm just indicating the timeline. The first PH notice, your Lordship, was 8th of August 2024.
I understand.
Second PH notice is 26/9/2025 after more than 11 months. 13 months.
Yes.
Then, Millard, I reiterate the request.
Anyhow, then 3rd November.
Then, Millard.
3rd November was fixed, that says 34. Anyhow.
Yes, Millard, that was not provided.
Yes.
And what was the response? Millard will kindly see page 29. To my 1410 2025 letter, they say, kindly see this, page 29 at the top. Gentlemen, the same may please be collected from SCN issuing authority.
Yes.
Then, my lords, 14th, your lordships will kindly take page 46, my lords.
Yes.
I write, as submitted in continuation of the previous mails, we do not have copy of SCN. We are not aware of the authority who might have issued the SCN. The document we have as of now is the notice issued by your good office for hearing. And that document, we do not find any indication who the relevant authority would be. As has been respectfully submitted, and this is quite an old matter, we sincerely request.
Then what happened?
Then after that, nothing. Again, we reiterate 7/11/25 at page 38, 7/11/25, another PH notice. We reiterate our request at page 40. And then, Millers, at page 42, the order in original. My humble submission, Millers, I request for multiple times that please give me, I want to participate. And he doesn't provide.
You are supplied, your lordship, at any point of time, have you confronted and supplied the material which he has sought for?
He is aware, page number 48, your lordship.
Awareness is.
He is aware when first peremptory hearing notice is given, he is aware that there is a show cause notice. What he says is that it was never given to me. For the first time, I come to know from this hearing. Please give me those copies. I just wanted to give a reply. Whatever I have, I can defend it. He has been repeatedly reminding you to use at one go, say that you can please collect it from the issuing authority. He says that since there is no reflection who has issued, I'm not aware. Where shall I go? Yet you remain silent for all time to come.
The matter related to 2018 notice was issued to him, but could not get the notice. He requested for issue a show cause notice. That is the only.
No, because he says that I was not served with the show cause notice at all. And it's an old matter, 2018, you don't know, you sat over it for a pretty long time.
And your lordship, and if you go for page number 48, he was involved in this matter.
No, maybe, sir.
And if request, on request, I will be providing the show cause notice, let him file an appeal before the appellate authority. I will be providing and take all the contention before the appellate authority. It's a mere of 3 lakhs rupees. He will have to.
It's a violation of principle of natural justice, apparent on the face of the record.
No, lordship, there also.
So why not we apply whirlpool and then subsequent judgment?
23 parties are involved in this case, your lordship. He is a mere party, and only if this will affect to all, your lordship.
What will affect to all?
And your lordship, I'll be if required, will providing the show cause notice to him and he take all the contention before the first appellate.
What appellate court? Who will decide? The authority may have, after looking at his reply, may have exonerated him from the entire episode.
No, lordship, yes.
Because that opportunity was not given to him.
And everything when the raid was conducted, they have given the statement also.
Who has given? He says I was not there. You say one partner. He says it's a individual name. I am running a business in my individual capacity. There is no question of any partnership business running. Even a route permit must be showing that it is issued in his name.
That point I will be taking page number 40.
What?
Page number 40
is the RC. The bus is in the name of Virendra.
No, it may be, sir. Don't. What the civil concept is different. You may be individually owning, but If you put your own property into the hodgepodge of the partnership, then
It's a different thing.
so we don't know.
Exactly.
So that's why don't say it is standing in my name. That shows there are multiple factors which can be taken into account.
So far as the second limb of argument, Millards, clearly 73(4)B the identical provision. Identical provision. Because if I may draw your lordship's attention to page 12 of the writ petition.
Oh.
(11)A.
Oh, this is.
The SCN was
It was
served by which mode?
But may I just indicate to the serving of SCN? All I'm saying is considerable time lapse has happened. Kindly give me a copy of the SCN. I am requesting for a copy of the SCN. Whatever you have issued, I will reply to it. That is what, because there is after 6 years below 2018 SCN, 6 years later, the PH notice is coming. So therefore, I request. All I want is Millards what? To participate, because I know Millards there is no complicity. And Millards will kindly take page 12 for a moment, Millards. It is
31. What is 31?
I'm sorry.
Page 31.
Necessarily, we should proceed to this.
Yes, 31 is actually Millards the reply.
Give me a provision of law.
If your lordship will kindly.
No, not
11A11. Central excise. This is the
Central excise.
I have quoted it at page 12.
What else?
The central excise officer shall determine the amount of duty under subsection 10 within 6 months from the date of notice, where it is possible to do so in respect of cases falling under subsection 1, within 2 years from the date of notice, where it is possible to do so in respect of cases falling under subsection 4. Even if it falls under subsection 4, it is 2 years. And if your lordships have the Finance Act, tax in relation to service tax, section 73(4)B is pari-materia provision.
Lordship, his reply in page number 25, he clearly showed the efforts of show cause notice somehow has been misplaced.
Yes.
I have seen that.
I'm not denying that. I clarified that.
Give me a service tax. GST.
Service tax.
Page 73.
73(4)B, that's.
Yes, the same thing. This is the
A also there is an order.
Take that to also.
And in the context of 11A11 also there is an order. Rate petition 5239 of 2025 of this honorable court.
The lordship, if this is also not applicable, page number 86. They have filed a case before the Honorable High Court. And the Honorable High Court had disposed of the matter in 2023. So that period should be also excluded if page number 86, para 7.1, your lordship.
Even if it's excluded, still it is not within 2 years.
Lordship, this assessment has been done on 23 persons. And the main persons are
So we are not concerned with the other persons, we are concerned with him. So far as the imposition of certain liabilities on him, so far as this case is concerned, that has to be adjudicated. His active involvement, his complicity to all these acts, the illegal acts, have to be ascertained, have to be found out. You are relying on a statement of a third party. You have
not on third party, lordship. If you go for page,
has he stated something?
Page number 48.
Please, then what is a statement? His statement or somebody else's statement?
I'll get that statement.
So, whose statement?
His statement is also there.
What? That he admits, yes, I was aware that he was carrying a gutka, I permitted him.
He was aware, lordship.
What aware?
That it was carrying contraband.
Page number 48.
It's not a contraband. Gutka is not a contraband.
It's not a contraband, but
it attracts taxes.
Yes.
That's an invasion.
Somebody coming and sitting in my bus having a...
Now it has become prohibitory goods. Yeah.
Yes. It's also
my humble submission is, Lords, I am not...
Many of you will be affected.
The other SSCs, your lordships, I do not have anything to do with that.
Here, when
I am only concerned about myself and confiscation of my bus.
No, your lordship, when the goods was seized, no, the person was not involved. The driver himself was involved. In page number 48, it is clearly stated. Your lordship, intelligence has indicated the passenger bus Dolphin service was illicitly transporting goods from Bhubaneswar to West Bengal and vice versa. One of the such bus bearing numbers this much at Babughat bus stand, Calcutta was searched. And in the result, recovery of 9,24,000 of pouches, Minaji was that. No document of illicit transport was same could be produced by the driver, Sri Ashok Das, and therefore the following
Yes.
And in the context of let's it is
Is operating between the Babughat and go for it.
let's it is
Go for an appeal.
it is time barred below this.
It's standard. It will be take of this position.
Because there is a
Here has spent much money in buying 2 books.
No, this was out.
It's worth 500 rupees. That is his book.
no, well, apparently he has not spent that much.
Yes, his book was
No, this book you have returned. Oh, that's true.
That is the court's. Because in the context of 11A11, there is already an order of this honorable court.
Please taken. Sorry, the order being original passed by
My please. May I take my lord's attention to page 24 of the brief, my lords. There's a lordship will find from page 24, my lords. On several counts, my lords, because the addition was made in assessment, which was dealt in with the appellate authority, my lords. And one of the case I am bringing to lordship notices, my lords, paragraph 5.0, disallowance of incentive, 25 lakhs, my lords. Just one, two example I am giving, small example, that was.
Why incentive?
Yes.
Why you want an incentive? You are an affluent businessman. Why you want an incentive?
I don't want bills.
No, you means
I mean
client.
My client bills.
That's affluent businessman. Why he go? Why for the?
Those are allowable. That is why the operators say allow this. The lordship kind it turned to one page after page 26. But out of this 25 lakhs lords, but in 5.4 your lordship will find the operator authority allowed has restricted the disallowance to 2.2%. Third line. During the assessment year 2010, the incentive payment is 1 crore was paid in cash. Therefore, in view of discussion herein above, they were directed to restrict the disallowance to 2,81,500. That is 2.2% of so and so. Therefore, the ground offer is partly allowed. Now, my lords, kindly turn to page 55 graphs. Page 55. This page 55, my lords will find the table serial number 5 that deals with this disallowance of incentive. In the right hand side column, your lordship will find relief allowed by CID. Because out of 25 lakhs, when mirrors, it is restricted to 2 lakh 20 mirrors. So the allowed mirrors figure is 22 lakhs 18,500. So without we are delving into so much of issues which has been addressed by the operating authority, rigid order is passed. Your lordship will found out of the total claim figure of 33 lakhs of odd mirrors, the relief granted is your lordship will find
16 crores 47.
There is addition. So page 55, your lordship will find 16 crores 47 lakhs 06,773 bills. Now my lords will kindly turn to mirrors page 52 mirrors. Thus after appeal order is passed mirrors, the effect is granted by assisting authority, deputy commissioner mirrors. And your lordship will kindly see page 52 mirrors. Your lordship will find assessed income in 33 crores to and so mirrors. Relief allowed by state appeal 10 crores 16 lakhs. But when each of the individual items I have reflected in accordance with the appellate direction comes to 16 crore 47 instead of 16 crore 47, which is actually it's a matter of free computation only. One doesn't have to apply one's mind below. But they quantified the relief granted is quantified by appellate authority. And the addition of the aggregate of all the quantity mirrors, the relief granted aggregates to 16 crore 47. And the lordship will find here at page 52 while giving effect to the appellate direction, it mentions 16 crore 16 and the composition of 10 crore 16 is not available. He writes here 10 crore.
Please, I understand. This was allowed by the appellate authority.
Exactly,
16 crore 47.
Total aggregate relief granted
while making a recomputation.
Correct.
He has assessed that 10 crore.
Correct,
16 lakhs.
Correct.
16.
And not only that,
can it be
not only that, one more figure your lordship kindly see the amount of tax which are paid. My lordship kindly come to page 53. Page 53, your lordship is same regular tax. Page 53, regular tax, 10 crore 47 lakhs 02674. Now my lordship kindly see page 57. How much I have paid? Page 57. Page 57, I have paid 10 crore 51 lakhs 80,482. So whatever I have paid, that is also not been taken into consideration for working out. Now he says the refund allowable is 2 crore 24 lakhs. I am entitled to much more than what he has calculated. It's a matter of computation only. So it is debilitating to not to follow rule of law itself. There are so many distance, the appellate authorities' directions. Because I have to be, because he has no choice to add or subtract.
That's true. He simply is an assessing officer, has to compute the demand or the assessment has to be made on the basis of the observation of the appellate authority.
Absolutely correct.
So he cannot sack over the appellate authority's power then that means that would tantamount to acting as an active appellate authority.
Correct. That is what consistently all courts says, right? You are quite
That is the very first principles of law.
rudimental. Yes. But I have somehow filed a rectification application, you make corrections.
Your Lordship, in this case, appeal effect orders passed on 11/12.
Have you challenged this appellate orders before that?
No, Lordship, they have filed a rectification petition. I have discussed with the department, and there is a time also we will be rectifying this rectification petition, but after March. I have already talked with the officer and we had a timeline also. So within 6 months, we can pass this order. If they have filed on 13 to 2025. Whatever the figure they are saying.
I understood.
We will be passing. I had that instruction with the department.
Real problem. Not difficult.
Yeah, let my friend do one thing. So far as admitted refund is concerned.
You can go in April.
It will be appearing on the first week of April.
First week of April. Whatever Lordship say, I will follow. But so far as uncontroverted refund is concerned.
We understood. Have you not understood their
Junior Standing Council has a resolution.
Your Lordship, when we interrupt, the Ides of March is very difficult for us in one month. Your Lordship says for depositing and here to delay.
No, yes, sure.
Item 19.
They have told that they will take the matter on the month of April.
April. Second of April.
Yes, there is no
On 10th of April, your Lordship, that it will take after 2 to 3 days, they'll take evaluation. After March,
they will be what to do.
Okay.
You bring up the order. Let's.
Item 19.
So the 9th of April, my friend.
9th.
Are you agreeable?
I am not agreeable. I want money. That your Lordship knows. Automatic.
Nine.
Item 20.
Well, it's item 19. I'm for the.
Yes, your name is recorded.
Matters.
Item 20.
Hello,
Listener is a education institution coming under section 1023 3 triple I AD.
An exemption.
This is an exemption.
Education.
Admitted petitioner has not filed a return as per section
Which is not a profit bearing is hearing.
Your Lordship, there is a law. Even if you are building an exemption, if your receipt is exceeding more than the maximum limit, that is 2.5 lakhs, he has to file the return. And if you file the return within the due date, then the exemption will flow. And he has not filed the return.
My lord,
during that period.
My lord, I have
so that reason the exemption was disallowed by the office department.
My lord, I have filed the return as per notice, after issuance of notice under section 148. Once a return has been filed under section 148, it should be treated as an original return. But as per Kulwali decision since 1970. Once I have filed the return, that has not taken into consideration by at the time of assessment proceeding, Lordship is going to page 33. Same thing has been here. Page 33. Last para above the table. In this case, the RCC has not filed return of income for assessment of 1617 in compliance with provisions of section 131 of Income Tax Act 1961. He has a filed return of income on 23/3/2023 in response to notice under section 140 of the Income Tax Act and declared total income of rupees nil after claiming exemption of rupees 74,69,712 under section 1023 AAAD of the Income Tax Act. The RCC is not eligible to exemption pertaining to the Income Tax Act if it is not filed return of income under
Decision.
Ulweli. Ulweli Transport Corporation. That is once, that is, I have mentioned in page 11. Thus, a return submitted at any time before the assessment is made is a valid return as per ratio of the decision of the Honorable Appeals Court in the case of CIT versus School Valley Transport Corporation Private Limited reported 77 ITR 518. Hello, my lords have given two decisions, my lords. Next page, my lords. My lord, when a technical consideration and cause of substance justice are pitted against each other, it is the substance justice which is to prevail. This is the Honorable High Court of Orissa in case of the
The notice itself, they call for filing of returns.
My lord, 148. Once a notice under section 140 is issued, it is the duty of the assessor to file a return. Suppose if he has filed a return and no variation is required, then he has to mention a return filed under section 113 should be treated as return pursuant to notice under section 148. Suppose if there is any variation is required, then he has to file the fresh return. Once that return is filed, that will be treated as original return, not the 139 return already filed. So we have filed return pursuant to notice on 130, 140.
Yes. Yes, we will say, look at the language.
There's also instruction. Requiring to furnish.
Yes, I've seen 148 language. And then application under section 147. And then look at the language of 139, obligation to buy the return if it exceeds a particular amount. So in that event, once the application, then it is to be assessment, reassessment and recomputation. So assessments can also be made on the basis of a return. So if it is an assessment, then this will be treated as a return to have been filed, and then you decide the where 139 has an impact.
139 4C.
Those are 147. 147 is what? Suppose 139. Suppose 139 return is filed. Yet you can assess if it escaped the notice. Will it be treated that it has not been an original application or a return? Will be treated. In that way, how can you say 139 is a contingent precedent? Is a second lease of life which is given by to him by virtue of 148 notice to file a return. What is the language of 148? It says that before making the assessment, reassessment under section 147, the assessing officer shall, subject to the provision of 148A, that's the preliminary one. We have already decided, dictated on that. Issue a notice to the assessing along with a copy of the order passed under 148A3, requiring him to furnish within such period as will be prescribed in the notice, not exceeding 3 months from such what furnish a return of his income. So it's the second lease of life to find a return.
Required under subsection 1, published after the expiry. Now it is not
Specified in the notice shall not be deemed. If it is filed within the period, then
that is not your case. It is filed
within the period. If he files beyond the period, provided in the notice, then in that event, you will not treat this return to have been filed under 139. That shows reverse. If it's filed, then it will be treated as a 139.
And the negative returns.
148 to proviso. It says provided that any return of the income required under subsection 1 furnished after the expiry of the period is specified in the notice under the said subsection shall not be deemed to be a return under section 139. So reverse is, if it is filed within the time, then why not treat it as 139? No, that's one. Cannot. Yes. Huh? Notice issued.
I have filed a IM.
Stay of demand. What is the appellate provision? How much? Whatever.
No, there is no precondition.
There's no problem.
But 220.
And 220 is a.
Separate, if you are paying 20%, then there is a stay of the demand. As per 226.
226 is 20% stay of the demand.
Then for average stay, if the petitioner is paying, when a petitioner, the assessor is paying, then automatic stay.
20%. 20% will stay. Will excite our
junior college. It's a junior. Headed
Bracket 6.
That's true. Okay. Will
Some doesn't matter.
20%. No.
Education instrument.
Statute says 20% you deposit.
But it is CBDT. That 30% is CBDT.
CBDT circular. Only 226, only we have to find the stay up.
Is that circular?
Item 21.
These matters relate to section 73.
Yes.
Item 23.
Please, my lordships. My lords, we are challenging my lords, order of the state GST department, my lords. The reason for challenge, my lords, is that the entire proceedings are devoid of natural justice, my lords. I applied for the relied upon documents on a couple of occasions after the show cause notice, my lords. The relied upon documents have not been given to me, my lords. Admittedly, they go on to decide the order, my lords. If my lords will peruse the order, it is replication of the show cause notice. There are no findings against me, my lords, in the order. If my lords will have page 37, my lords.
Your Lordship, I have a preliminary objection, Your Lordship. Your Lordship, acceptance. Your Lordship, this is within limitation, Your Lordship, and factual finding, and this is a case of fraud, Your Lordship. So far as the entire adjudication has been made on the ITC.
We are just going into that. What he says is that there is no independent finding recorded by him. It is what is simply quoted from the so cause notice and pasted here.
Absolutely, my lords. That's my humble submission, my lords.
Tell me that what the appellate authority will do. Show us, just find out.
Your Lordship,
find out that it is a really copy paste one.
Page 37, my lords. Please, if my lords will have it, page 37.
Yes, 37.
My lords, this is the order of the original authority, my lords. He says in the center of the page, my lords will have discrepancy found. They rely on one internal letter dated 26 August 2025, which is between them, my lords. And they say that for the period 18, 19, 19, 20, 21, 22, 22, 23, you have received ITC fraudulently, my lords. This is what they allege, my lords. This is the assessment order for 1920, my lords. My lords will have the next page.
Yes.
Hence, it is a fit case for initiation of proceedings under 74, 1 of the CGST, SGST. And he produces section 74, my lords, 74.1. Next para, my lords, at last. Accordingly, DRC01 was issued so and so date, to which you have asked time to collect documents, wherein I have asked them to supply me the relied upon documents. And they say that I don't participate in the proceedings. My lords, on 2 occasions, I asked them to give me the relied upon documents. They just noticed that, observe this portion, my lords, and pass an order against me, my lords. If my lords will have page 58.
Yeah,
My lords have it?
What?
Page 58, my lords.
What is that?
That is the show cause notice, my lords.
Yes.
My lords, if my lords will have the topmost heading line, my lords, it says annexures to form GST DRO.
That has been rectified. That has been wrongly typed. Your rectification order has also been uploaded.
What?
That should not be suppressed. With great respect, that should not be suppressed. That has been rectified and rectification order has been uploaded.
What? Let him complete. He has not completed. What he wanted to say at page 58?
They are entirely predisposed, my lords, as far as their adjudication is concerned. They have decided beforehand only that they have to fortify the liability against you, my lords. Therefore, in the show cause, my lords, they give me an annexure to form DRC07, my lords. Now, kindly have the body, my lords. It is the same as the order. No difference, my lords. All the paras are same.
Yes.
Next page, my lords, is the same thing. In fact, my lords, he rectifies the DRC07 on 22nd January, again does the same error and passes the same order, my lords, without doing anything. There is no finding, my lords. In fact, if my lords will have page 301, on 2 occasions, my lord, I asked them to supply me the documents based on which they are concluding against me that the ITC is fraudulently availed.
The only ground is that you have failed to give a reply and then the judgment is...
My lords. My lords, as far as Annexure 1 and Annexure 2 are concerned, my lords, I go down to my lord,
this is what you have done. If both the documents are kept side by side, word, comma, full stop is also same.
And prima facie.
And subsequently,
except one line. Even a prima facie has gone. You have to come to a conclusive finding.
Your Lordship may remind the matter with a time stipulation and direct the petitioner to cooperate in the proceeding and to participate in the process.
We are saying what documents you have asked for.
My lords will have page 301 for a moment, my lords. Page 301.
What documents they have relied upon, which you will ask for?
My lords, they are saying that they have cancelled somebody, one of my suppliers' registration, my lords. They are relying on their internal communication. My lords, now what has happened? What kind of investigation has taken place at that?
That is, sir, that is what you do not know. There is no document which they have relied upon.
My lords, I don't know which document they have relied upon to conclude this.
What are you talking about here, too? Nothing. No. Not relied upon. What document? You say that the supplier is non-existent. What document they will supply? It's not there. They are not registered. That's all.
If I may submit, my lords, for a minute. My lords, they are saying that the supplier is not in existence, my lords. I have bought goods from that supplier. Have they investigated that supplier? What kind of investigation has done it?
This is if there is nothing, you have shown a fake the certificate or a fake registration number. There is no existence of a supplier.
I am not fake, my lords. I am not fake, my lords. As far as I am concerned,
simply say there is no such supplier of this name or number.
As far as that supplier is concerned,
you have to then shift on you to show that he is a genuine supplier. Final transactions.
There is transportation, everything. You give all the
Manoj, if I may submit, Manoj, for a minute. Manoj,
No, sir. We are simply permitting you to go and file a reply within a time you decide. We will not say anything for supply of the documents.
Manoj,
we have successfully proceeded. They have committed a blunder in just copying and pasting it. That's the only ground. Otherwise, would not have.
I bow down, Manoj.
No,
I will
sorry.
participate in the proceedings.
You will not permit you to steal a march there.
Well, I'll participate.
Yes, you go file, no insistence for
personally, three repetitions have been filed and withdrawn. And after that, on the last
because they have made the first petition.
When filed.
I have done the mistake.
First petition was filed in the month of December, Manoj. They passed an order on 3rd January. That became infructuous. Manoj, I filed a second petition. That petition was filed as a rectified order on 22nd January, Manoj. That again became infructuous. Manoj, then third petition was filed. Manoj, I humbly submit, Manoj, there was a mistake in the third petition from my side, Manoj. And Manoj, because I am constrained.
The liberty was granted to you.
Manoj?
Liberty was granted to you.
Manoj, as far as the
when you have withdrawn.
Manoj, that I'll withdraw, Manoj, in due course. Manoj, I am submitting.
No, it is still pending or you have withdrawn?
It is pending, Manoj. It's pending.
No,
it's dismissed for default. The last petition was dismissed for default.
Dismissed for default in your presence or in your absence?
In my presence. His absence.
My absence.
So it is not restored. If it is not restored, tell me whether it is maintainable. You have challenged the self-same order in that writ petition?
Yes.
Manoj, I have challenged, Manoj, DRC.
I am asking you, sir, very simple question, then I will take you to law.
Manoj.
You have challenged the self-same order in that writ petition which got dismissed for default?
No, Manoj. Manoj,
what order you challenged there?
Manoj, it was order dated 3rd January 2022, Manoj. Whereas today I am challenging order dated 22nd January 2022, Manoj, 2026, Manoj. It's a rectified order. Order dated 3rd January merges with the order.
If it is a different order, then there is no difference.
Not different order. The last one.
Sure, sir, I am asking. He says no. The third writ petition, I have not challenged this order. I am challenging the earlier order.
Yeah, let's see. Let it be taken up tomorrow.
Please ascertain if it is.
The last number is 1439 of 2026.
You will not be able to gather that.
No, sorry, 4955. Yeah, let's see. Kindly looked into the cost item. Page 2.
Well,
the WTC number 4955 of 2026 challenging the rectified order dated 22nd January 2026 along with DRCA. Here you will see the same order has been challenged.
4955, Manoj, I agree, Manoj.
Exactly. That
is what wanted. You, sir, said something else. I simply said that the last writ petition which got dismissed for default, in that petition, did you challenge the same order which you have challenged in the instant writ petition? Please tell me very straightforward.
Manoj, if I may submit, Manoj, 4955 has not been dismissed for default.
Same is an order 9 against you.
Manoj, 4955 is not dismissed for default, Manoj.
I do not know. It is dismissed for default. It is already there.
Manoj, it's already there.
It is showing pending.
It is there, Manoj. It is there.
Then where is the dismiss for default?
That was 1439. That was 1439, Manoj. 1439.
3654.
143.
Mr. Mishra.
I'm sorry.
You should not have. You should not have proceeded on the mere something has been whispered in your ear. I was applying the principles of law that even if it is a dismiss for default, but it was in your presence, then he is precluded from filing any further proceedings for the self-same reliefs or challenging the self-same order. A bar of res judicata will apply.
Let me examine your.
If it is pending, then it's a pending.
Pending on same period.
1439, what was challenged?
Well, it's 1439 order 1439 DRC 07 dated 3rd January 2026 was challenged, Manoj. during the pendency of this petition, my lords, they rectified the order, which was challenged again, my lords, in the present petition, my lords.
So why the second writ petition again? If you have already challenged the other writ petition, then why this writ petition again?
I will humbly submit, my lords.
If the third one is pending, then why you are filing again?
Allow me to clarify. Allow me to clarify, my lords. Allow me to clarify.
So default is not restored.
No, that was in respect of a unrectified order. So no difficulty. Rectification order gives a fresh cause of action.
Allow me to clarify that, my lords. If I may humbly submit, my lords. My lords, petition number 4955, there was an error from my side, my lords. One impugned annexure could not have been filed, my lords. Considering that my appeal is barred by limitation on 31st of March, and if my lords would have not been inclined to entertain me, my lords, there I was bound by Singh Enterprises, my lords. I found it more easier to file a fresh petition with liberty of my lords to withdraw that petition as in the due course, my lords. This was
Where is the liberty? Where is the liberty sought for?
Well, that petition has not been heard, my lords. That petition is not.
No. Where in this petition you have? Where is the petition?
I've declared, my lords. I've declared that it is filed.
Where?
My lords.
Where you have sought for withdrawing the said writ petition?
My lord.
Or any IA is filed here? Which one? No, I understand. What he does not understand. He does not understand what is.
My lords will have page 2, my lords. Page 2. My declaration, my lords. At page 2 of the petition, my lords.
1439. Dismissed for default. That has not been.
You said that other one, 4955.
4955 pending.
Dismissed for default, my lords.
4955 is pending.
No, my lords, 4955 is pending, my lords. Yes.
Oh, in the same prayer.
Same prayer, my lords. Which I will withdraw, my lords. Which I will withdraw.
After filing this.
Second subsequent request. Yes. Whatever. You could not know.
No, Lordship. In fact, this WPC number 4955 was 2026.
Sir, when that was pending, that was against the rectification order.
Yes, ma'am.
Subsequent rectification, how could you cry?
Yes, Lordship. I'm just explaining. Lordship, this WPC number 4955 of 2026, it was filed by some other counsel, not by me. So when this matter came up to me, Lordship, I saw there are some defects in the documents.
So
the document mentioned in the petition. Lordship,
there is a defect in the earlier one. Without seeking leave, can you file the second one?
Lordship, the difficulty
was same cause of action and same.
I apologize for that, Your Lordship, but what I thought
prudent was original, two original copies.
Sorry, my lord.
When here original copy you don't have enclosed impugned order.
It was uploaded in the portal, so that
you treated to be original. As many times you can use. But challenging the same.
My lord, I'm sorry. Lordship, because had it been a
very pure.
Lordship, because had it been a defect in the pleadings, it would have been amended. But lots of documents were not annexed. So that's why it was. I thought it prudent.
Sought for the leave.
I'm sorry, my lord, because in that matter the earlier counsel wasn't cooperating, and I couldn't have filed a memo for withdrawal. So that was the difficulty. Hence, it was my suggestion that we will make a declaration in the petition itself. We will seek leave on this. But no order has been passed in that matter. It has never been taken up.
Oh, that is there. Order 23 rule 1, I know. I was. You satisfy us on the maintainability. Mr. Counsel, you satisfy us on the maintainability.
My lords, if I may see.
Sorry, unless you sought for a leave under Order 23 Rule 1, whether you can sue or file a fresh suit for the cess and reliefs.
My lords.
Sorry, we cannot.
My lords, the only difficulty is, my lords, that.
No, there is no difficulty. Suppose if the court refuses you to withdraw the said suit, or may refuse to grant you a liberty, then what will happen to this suit?
My lords.
So, because the language is where the court is satisfied, then it will permit you to withdraw. Otherwise, court will not permit you to withdraw. Satisfaction of the court is paramount.
My lords, I will satisfy as far as 4925 is concerned.
You just say that it is maintainable, even if you have given an undertaking that I will withdraw the earlier proceedings.
My lords, if my lords may grant me some time, I'll satisfy my lords.
Take.
My lords may have it next week, my lords.
Yes, take your time.
My lords may have it next Thursday.
If second.
It will cross my single enterprises limit.
Then next week is which date?
26th.
Any date with my lords permit, my lords.
20?
26th March.
Next one.
This
26th March.
Oh, 26, yes. Come on, 26.
My lords, oblige, my lords, oblige.
Item 24. Item 25.
Item number 25, this is the flooding GST accident.
26.
73.
Item number 27.
There's a additional with the license of also. Now, his shop was closed by the public and for breach of peace, and there is an order was passed by the collector under section 26 of that. Thereafter, he was issued a demand notice. The demand notice was under challenge before this own court, and this own court was the demand notice. Lords, you kind of glanced at page 27, the order of this own court where the demand was quashed.
The synopsis has been given.
The order was passed by this own court. If the Honorable Court quashed the order, but there is a judgment has been observed in paragraph 6, where Lord, it says that if the shop is closed for breach of peace under section 26, then the demand and the petition is entitled for refund of license fee has deposited. So, Lord, on the basis of that, I have filed an application before the government under Annexure 7 for refund of my license fee because it is closed for 15 months, Lord. So, Lord, I have deposited about 9 lakhs, 10 lakhs, Lord, license fee.
Yes, what you say. And they are
not refunding.
They have issued an order for closure.
Yes, Lord. Annexure 3.
Yes. So what? If you have issued an order for closure, how can you continue and retain that amount?
Take instruction. I have relied on the judgment of this own court, and their order has been passed at page 44.
Where is your application pending?
Annexure 7.
So let them decide that it's a.
On the basis of my application, they sought for a report from the collector and commissioner, but collector is saying that when the shop has not been approved for more than 3 days of closure, so it doesn't arise. The collector has written that.
What?
No, at that time,
it is closed for all time to come, you are saying?
Yes, no. But collector is saying the approval
No. The order of closure is passed by whom?
Collector.
So,
but he is contrary to, he is saying that when the commission has not approved more than 3 days, so it is not, he is not entitled.
So you could have operated, So these are essentially a question of fact. You go and decide.
But I have stated, I have given also a judgment of this own court and also
the order of closure served upon you that you can't operate.
Yes, I've given.
I've given, so you let them decide that. That is case of consideration of the application for refund.
That rule came into 2017. It is not 2015 matter.
Let them consider. We are directing them to consider. Yes. Both
are certain.
Yes. Next.
Item 28.
To consider.
Item 28 के workshops.
Yes.
What we challenge is a demand of
the transport fee when you are importing and paying the import charges.
Yes, Your Lordship. Because by the definition,
How can it be a double taxation?
there is also an order of this court.
The definition, the movement of the goods according to you constitutes an import.
Because
It also includes an import, and therefore, once the import tax is introduced and the transportation tax is introduced differently, then they are mutually distinct.
Exclusive, Your Lordship. They're actually mutually exclusive by the very definition, and in fact, the use of words.
This is a very pertinent question of law.
On the and an audit observation, Your Lordship, their internal audit observation. And there is an earlier order also of their department that once it is covered by the concept of import, you can't have a transport fee. This is a small order of this court, Your Lordship, very similar commodities, similar situation, because it's not a very detailed order.
What is this clarification that came in 2009?
Clarification of the department. Earlier also these audit objections were raised. I have also annexed that clarification, Your Lordship, which says
Yes, that is what they say. They have imported, they have paid whatever the charges that is there. Why there will be an additional transport fees or a duties or a tax?
Next week.
What happened? This is the only point. Can't be.
It is very clear in paragraph. Clarification issued by Accountant General by Excise Commissioner. Issued to the Accountant General by the Excise Commissioner.
When it comes from the consignment comes from the outside the state, and they are admittedly buying from the other state.
It is applicable only where the consignment goes from one place to another within the state. Very clearly laid down. Your own clarification.
What more we are disposing of? Yes.
Item 29.
Have you checked all the provisions?
Yes.
Because we are relying on you.
Quoted all of them. Your Lordship, one second. All of them are quoted.
That clarification?
Clarification is also annexed. Your Lordship.
Annexed.
Yes,
Item 29.
Item 29. I mean,
Why you wanted to have no competition?
No,
let your competitor be there.
No, it's not that. It is not a question of competition.
Yes, it's a question of competition.
I'll explain that here. My shop is on shop.
100 meter, 50 meter, I have seen.
Yes, Your Lord.
I understand. That means that you do not want anybody to within the 100 meters to sell the shop or sell the whatever.
That is the administrative side that already it has been decided, Your Lord. In 2010, the collector has said whatever shop has to be shifted, it should be more than 100 meters. I find
there is no law, statutory provision is a policy decision.
It's a policy.
If they have taken
Now-
50 meters, then what is the wrong in it?
Why I say I have filed an objection to that effect. That objection is not taken into care.
May not be worth taking.
No, because price they have.
They may think it's not worth for to be taken up.
If the Form A notice has been issued, Your Lordship. If there is a shifting, any objection, a Form A notice is issued, Your Lordship. In terms of Form A notice, I have applied that I am objecting to such shifting. They should consider. Now they have
already been shifted. They are operating.
To my knowledge, if they have not yet.
I do not know.
To my knowledge, they have not because
Objection has to be considered. Yes? Take instruction. 27th. Let's take instructions. Come on, 27th. Yes. Yes. Maybe 26. Oh, 26, whatever. 26. Yes.
I don't know, 30.
Wait, please, Your Lordship. The previous date, my lords, directed the department to take instruction, the mode of the service of the notice. For Your Lordship's kind remembrance. The order state which I have annexed and Your Lordship will please to see the order sheet at page 23. That the reassessment one was initiated under section 147 of the Income Tax Act. Then notice under section 148 issued. 2, and there is nothing in the bracket. When it was received, by which mode it was, people nothing.
Where is that? Show us.
The mode of service was post speed post.
Yes.
That is WPC number. Here it is WPC number 23165. Not
Oh, no. Notice under section 148 was issued on the same day, 29/3.
Notice under section 148 dated 29/3/2017. Dispatch on by dispatch number so and so.
Correct.
So which mode? By which mode?
Yes, he has a supporting document. He is a supporting document. Next page. The 115.
Yeah. And then there is someone wants to.
No, just wait 1 minute. I'm making a very deep scrutiny of the same. No, sir. 148 notice not served. Absolutely not, sir. I have seen checked up. You are talking about it, there is no document in support thereof. All other notices were served, 142, 140, everything were served. Shown to have been served. 148 proceeding, you have not.
Then you have also let him file an appeal for the Assembly Authority.
Yes.
On the basis of the order he has procured from us on 2025.
Well, this language is not procured from us, not appropriate.
Absolutely. I fully agree.
And then I will cite only one judgment of this honorable court by Justice G.B. Patnaik. When he was the judge here, I will cite the assessing officer gets the jurisdiction to reassess only when it has been served on the dealer. I'll cite only one judgment.
Whether it is not.
It is the case by the sworn.
Which page do you say? Which?
Tell us which page.
On the first year for the assessment at 2011.
Where is a proof that you have dispatch, even a dispatch register you have maintained for others, you have not given for this? Close. Dispatch register you have? Show me which is a dispatch register. Tell us. Tell us.
Right.
For assessment at 2012-13.
Sir, we are talking about the notice under section 148 is the foundation for initiation of that particular proceeding, and which led culminated into an order. So if that notice appears to have not been served, then he has an opportunity to file a return in terms of that particular notice under section 148. But that opportunity is lost.
Not the matter is set aside or well, final appeal because they are applied for the certified copy and he has been given on 24/7/2025 and he filed an appeal before the appellate authority.
He has filed.
No, he will have to file that.
Lordship will kindly.
What is the scope of this writ? Challenging the order or?
Yes. Challenging the order.
Not so.
Now, when jurisdictional notice itself is not served, it's
let me take all
then
It strikes at the root. It will be a simple ideal exercise relegating him there.
and the language is
If there are something in one of the matter, after hearing 2 words from you, we have remitted him to the appeal. Because we are aware, at least I can share that I am aware what happens, but not in every case.
and this highlighted the parts
Not
are
matching
not-
with the date, at the top.
That's what I'm asking.
Not matching with the date at the top. It is a date of 29th March 2017. No document of 29th March 2017. Not there. All documents prior or after. 14 you have produced. At the top, date.
The other one, assessment year 2011-12.
Yes.
In 11-12 Lordship, he has received a notice under section 143(2). And it's at the first page.
143-2.
Yes, sir. First page.
Yes, sir.
But there is no date.
I am not talking about
This case is one.
12:30. There if he has. Go and find it.
11-12. I am not here in 11-12. I am only on the reassessment of 12-13 ballots. That is 23165.
No, here put 2 restrictions.
Yes.
23933, is it flat here?
Yes, sir. 23933 11-12. Where I will file appeal. No further.
Next case.
The documents galore that you were served.
Because I not sir.
The documents below that you were served with all the notices. Here, in the second case, they could not show that the documents were served or notice was served.
Yes, that is the 23165 now. That is the
Yes. Yes.
Okay.
Brother, on that is COVID.
23165.
And this is the judgment. It's a furnace return within the time which is indicated. Two 3933, you go and find it.
Yes. 933.
Dispose.
23933. I'll file it.
This has to go. This first one has to go.
Both of them electronic filed actually.
What?
Both the cases electronic filed actually.
So what? First matter cannot. 3933.
The next matter. Item 31.
Yes, it is again disposed of, relegating him to file an appeal. Yes. Next 27th. Huh? 26. Oh, sorry. 27th. I'll give it on 26. Rest of the matter will be on 26 at the first.
Item 42.
No,